Good morning, ladies and gentlemen. My name is Mark Velasco, I'm the Deputy Secretary of State for Elections. Are you all able to hear me all right? Perfect. Thank you. Looks like there's a handful of other individuals that are joining still, so we'll wait a few moments, let them get their audio configured, and then we'll jump right into it. Appreciate your attendance this morning, though, and I'm looking forward to our discussion today. So I'm going to mute and shut off my video for about another 3 or 4 minutes. Okay, good morning, ladies and gentlemen. My name is Mark Velasco. I'm the Deputy Secretary of State for Elections. Appreciate you joining me this morning. Again, there's a couple more folks that are still joining. I'll drag my feet a little bit, but then we're going to jump into it in the interest of your time. I do appreciate you joining me this morning. Many of you I see from yesterday as well. And again, I tremendously appreciate your input. I was able to talk to the Secretary last night and again, let her know about the the significant amount of feedback and input and involvement that we're getting in this process, which again is her exact intent. Part of the reason why you may have noticed that the initial workshops for these sorts of as part of this regulatory process only have to really be noticed 15 days in advance. But the secretary wanted us to give everyone 30 days, really for two reasons, right? One was to make sure that individuals were aware of it and had the opportunity to review the documentation that we provided. I think it came to about 258 pages, I believe, when it was all said and done. It's spread across the 3 days, and that's not the sort of thing that she wanted us to just pass out, publicly notice, and then jump into. So we extended that time for the notice to allow you all to have the opportunity to read those documents and to provide feedback, and she definitely appreciates that. So I'm going to start the workshop now, though. Good morning. I'm calling this hearing to order at 0803. Now, for the record, I'm Mark Velasco, Deputy Secretary of State for Elections, and I will be conducting this regulations workshop today. Before we begin, I would like to clarify a few things. Our discussion today during this workshop will be focused on proposed regulations listed in the agenda. We should not discuss changing statutes, which are, of course, created by the legislature. This regulatory process that we're conducting today will not alter any existing laws. If there are general questions about elections procedures, I'll be able to discuss them as long as they relate to the proposed regulation. If there are questions that extend beyond the regulations on the agenda, I would be more than happy to set up a separate meeting at another time. To do so, please contact me at nvelect@sos.nv.gov. This is the public workshop for the Secretary of State Elections Division's proposed regulations with the LCB file numbers of R099-12, R100-12, R101-21, excuse me. Let me start over, just make sure I'm just reading them accurately. R099-21, R100-21, R101-21, R102-21, R103-21, R104-21, R105-21, R106-21, R107-21, R108-21, and R109-21. The text of the proposed regulations has been provided. The notice of the workshop to solicit comments on proposed regulation was noticed at all required locations on December 22nd of 2021. Each of these documents is hereby submitted into the record. As of Tuesday night at 7 p.m., the Secretary of State has received written public comment from multiple organizations and approximately 60 individuals. Since then, we've received approximately an additional 50 emails and other written forms that I am still reviewing. The written public comment received by the Secretary of State's office is hereby submitted into the record. Finally, one administrative note, actually two of them. First, I will be taking notes while you are providing comments. If you see me looking down, please understand it's because I'm typing, so I can make sure that I'm recording your information. This video is, of course, being recorded as well, so that we can go back and reference any comments that you make. So again, please don't worry that if you talk fast, like I sometimes do, that we're going to miss something. We will absolutely review it. That's the deliberate part of the reviewing, or the recording. And then second, for the conduct of the meeting today, if you're new to Zoom or haven't used it in a while, there's really three ways that you're able to raise your hand to indicate that you're interested in providing public comment on an agenda item. The first, if you look down in your bar here, the status bar on Zoom along the bottom, and depending on the size of your screen, you might have to go to the more button there. But there's a reactions button where you can click the bar, the icon that says raise hand, and a little hand will pop up and you'll see it like mine just did. If you do that, again, that will indicate that you're interested in providing public comment. Alternatively, a little bit old school, you can just raise your hand and I'll keep an eye out for that as well. And then lastly, if you have a comment and you're otherwise unable to indicate it, please just put something into the chat as well. And if you say, I have a comment, I'll make sure that as we go through the agenda, I will review the chat box as well, and to make sure that we have afforded everybody the opportunity to provide their public comment. Okay, agenda item 2, public comment on matters other than the previously listed LCD file numbers. Comments will be limited to 2 minutes per person. Is anyone interested in providing public comment about a matter not on today's agenda? If so, please identify yourself and be sure to state your name for the record. I may ask you to spell it if need be. If you've got it on your screen, I'll be able to just use that. But at this time, is there anybody interested in making public comment on matters other than the previously listed LCB file numbers?
Yes, Mark. This is Robert Beatles, Washoe GOP Central Committee Election Integrity Chair and Precinct Captain of 5030. I just kind of want to reiterate that the Secretary of State is the Chief Election Enforcement Officer. Same with judges. They enforce laws. They don't make laws. The Secretary of State is trying to make laws without legislation. The power that you say that she has via the NRS 293.124 and 293.247, which is clearly an error. It's unlawful and unconstitutional to adopt regulations. It doesn't mean to draft or create new laws or regulation. The legal definition, according to Merriam-Webster and many other legal dictionaries out there, is to accept formally and put into effect. It has nothing to do with recrafting. This workshop or hearing, again, further disenfranchises non-computer internet voters. If you guys want to do something of real importance that really benefits we the people, start by deleting our voter rolls and stop using something like the Electronic Registration Information Center, also known as ERIC, that appears designed to turn every person, not citizen, into a voter. In 2010 to 2020, we had a 15% population increase in Nevada, yet we had a 166 increase in voter registration. Of that 15%, it made up 440,000 people. Of that 440,000 people, it was comprised of but only 44 last names. That's right, 44 last names. We had 44 last names that got 10,000 new people attached to them. So 44 last names times by 10,000 equals 440,000. That was our population increase. How can we have 218% voter turnout? Mind you, all this data came from the census, the county clerks, and the Secretary of State's. How can we have a trustworthy election if we can't audit the machines, the source code, and audit the physical ballots? The answer is we can't. What we're doing here is only worsening the problem. It does nothing to ensure election integrity. If you want to really, take election integrity serious, you should follow our petition. It's on operationssunlight.com. And then lastly, we got to know, can you tell us what's holding you and the Secretary of State back from doing what will restore confidence, save a ton of money, and make our elections legitimate? Please let us all know. Thank you.
Thank you, Mr. Beatles. One moment. Mr. Greg Ott has joined us today. He's a Deputy Attorney General and works with the Secretary of State as our part of our legal counsel. Mr. Ott, do you have any comments on just to address the legality of this process that we're about to undertake today?
Yeah, we touched on this. For the record, Greg Ott, Deputy Attorney General assigned to assist the Secretary of State. We touched on this briefly yesterday, but for anybody who didn't join, NRS 293.124 subsection 2 gives the Secretary of the State the right and the ability and the power to adopt regulations regarding the chapters under her purview. Whenever the regulatory process starts, the agency or the individual with the power submits a request to the Legislative Counsel Bureau because all regulatory power has to flow from the legislature. So the Legislative Counsel Bureau reviews the request, makes sure that the power has actually been delegated to the Secretary of State, and then says, okay, you can commence the process. Additionally, if our office was aware that an agency was acting outside of its regulatory authority, we would tell them to hew more closely. All this is to just give a little bit of background to those who have any concern that the Secretary is acting outside of her power. Our office has looked at it. She's entitled to proceed with these regulations. LCB has looked at it. They're entitled to proceed with these regulations. If you look at NAC Chapter 293, you'll see next to every regulation that's adopted, there is the legal authority for it, and it's frequently 293.124. So historically, this provision has been used to adopt regulations giving clarity and detail to the laws that are adopted under Chapter 293. So, Mr. Beatles, I think you may disagree with that statement. I know you mentioned attorneys previously that you work with. I'm happy to talk to them about it, but I wanted to clarify that lawyers have looked at this, and the Secretary of State is within her rights to proceed with these regulatory proceedings. Oh, and I guess the final thing is, at the end of the regulatory process, the regulations do go before the Legislative Commission, which is composed entirely of elected officials, members of the Assembly, members of the Senate, who decide whether the regulations should be adopted. So there is legislative oversight at the beginning by delegating the authority, and then at the end by looking at the individual regulations.
Sure, but real quick though, I mean, 293.124 says that she can adopt. What you guys are doing right now is changing regulations. You guys are changing essentially law and then sending it to a legislative commission is made up of 6 Republicans and 6 Democrats, and the 6 Democrats are in charge of it. They're the chair and the vice chair, including the new attorney general. So who's going to break the tie? I mean, this isn't what we signed up for, and it clearly adopt does not mean craft, draft, or any of that kind of stuff. So I'm not sure what your attorneys are reading, but who's going to break the tie if it's a 6-6 split at this commission, especially when you got a Democrat chair and vice chair?
So I just wanted to make sure that you were aware that it had been looked at by our office, by the Legislative Council Bureau. When things go to the Legislative Commission, they get advised by their lawyers. I'm not going to get into what their process is. I just wanted to make sure that you understood that this process has been vetted and is within the historical practices of the Secretary of State and is consistent with the readings of the law. So I'll turn it back to the public comment and to Mark, and hopefully be quiet for the rest of the day. Nobody wants to hear lawyers, so I'll try to be quiet, Mark.
Thank you, Mr. Ott. I do appreciate your input, though. And actually, one last thing I'd like to caveat on that, too, just to provide an awareness for everybody. This regulatory process, one, is identified. The Office of the Attorney General provides an administrative rulemaking guidebook that explains the entire process, cites the statutes that drive the process, and explain the timelines as well. A very, very important part of that process, exactly what we're doing today, where we receive public input. Part of the reason, again, the Secretary wanted us to announce it and provide additional time for individuals to provide feedback is specifically so that we can gather public input. This is not something that we're doing, we could do, quite frankly, on our own without you. We truly need and appreciate your input. That being said, Ms. Sandy, do you have some comments that are on an item not related to the agenda for this portion of public comment?
Good morning, I do. Thank you, Mark.
Will you be able to state your name for the record, please?
Yes, I'm going to. Please give me patience. Yeah, my name is Sandy Tibbetts. I am a Washoe County registered voter who knows there was fraud in the 2020 election. I am one of those disenfranchised voters and feels that this workshop is a sham. It's bullshit. I apologize. My language is probably why I didn't say anything yesterday, because I'm frustrated with this whole thing. I do want to thank all of the patriots that spoke yesterday. They had lots of common sense suggestions. I believe, and it is in your best interest, and everybody that's on your election team, that you take serious consideration about Mr. Beadle's plan. Paper ballots, voting at the precinct level, polling locations at the precinct level. Common sense, people. It's common sense. Mark, you used a word yesterday that I don't believe that you even understand the meaning of. Do you know what a patriot is? A real patriot wants free, fair, and transparent elections. There is no patriot that I know that would be the voice of these mail-in ballots or be on an election team putting together this crap. It's fraud. It's an instrument for fraud. Thank you. I got more.
Thank you, ma'am. I appreciate your comments. Mr. Parks, do you have a comment regarding something not on the agenda this morning?
Certainly do, Mark. Thank you. First of all, I would like everybody in attendance here to understand something. We have this book of laws, and if you don't think they're not laws, all you have to do is violate one of them. It's called the Federal Registry. And now this is at the national level. How many of you are aware that there's 40,000 regulations attached to the hamburger that you got from McDonald's yesterday? 40,000. We have unelected bureaucrats making laws for us every single day. Now, while I understand that the NRS allows for the Secretary of State to perform certain functions, creating law, dictating to us how our elections are going to be operated. Well, sir, all I can tell you, Mark, is we the people are in charge of this country, not a bunch of elected officials or unelected bureaucrats. We the people want fair, honest, open, transparent elections. Over 80% of the country is in favor of voter ID laws. Why is that not something that we are discussing? If the Secretary of State was really interested, sincerely interested in fair, open, and transparent elections, that would be one of the items that we would be talking about during these 3 days. It's not anywhere on the agenda. So I question the sincerity of the Secretary of State and this entire process. Thank you.
Thank you for your comments, Mr. Parks. Ms. Thomas, good morning.
Good morning. Can you hear me?
Yes, ma'am, I can.
Okay, good. Thank you. The first statement of each proposal affirms that the NRS 293.124 is that this agency is responsible for the execution and enforcement of the previous provisions of Title 24 of NRS and all other provisions of state and federal law relating to elections in this state. Therefore, the responsibility to enforce every part of the regulations is further acknowledged in item 6 of each proposal regulation. It cannot choose to enforce some and not others. As such, any and all references to person must be corrected to citizen, as is directed by Title 52 of the United States Code, Section 10101, Item 1, all citizens of the United States, and NRS 293.485, qualifications to vote, citizenship. Item 1, every citizen of the United States. Any person cannot participate in our election system. Only citizens are legally allowed. This is further supported by being the very first question on the application of voter registration. In light of the events happening in other states and at our southern border, it is imperative that no window of opportunity be provided to risk misinterpretation or manipulation of these regulations. On April 13th of 2001, at a Washoe County Commissioner meeting, that this agency stated, the Deputy Secretary of Elections stated that this agency is not currently verifying citizenship of applicants registering to vote. Every person that gets a Department of Motor Vehicle driver's license in the state of Nevada is not being verified whether they are a citizen. So therefore, our voter rolls have been polluted with non-citizens. There is nothing on any of these agendas that have suggested a procedure on how to clean our rolls from non-citizens that are already there. Not even less, needless to say, the ones that are going to be continuing to apply for them. So I urgently and implore you to please put something on one of these agendas and developing a regulation to apply to uphold and enforce the NRS 293.485 and the Title 52 of the United States Code. Thank you.
Thank you, Ms. Thomas. At this time, is there anybody else interested in, sir, Mr. Williams, please.
I have a quick question. Can you cite the NRS or NAC for the Electronic Registration Information Center, the ERIC system? Where is that? Where's the law that says we have to use that system and fund that system?
In the same sense that there's no law that says I have to wear shoes. There's no law that says I have to wear the electronic registration.
But this is where the Secretary of State adopts a regulation. This is a good example of an adoption.
Yes, sir.
All right. I take issue with what you said before, though, and some of Mr. Ott's comments. The text of these things are rewriting the laws, and you say you're not changing laws. I don't think you're being honest, sir. Thank you.
Thank you for your comments, Mr. Williams. This time, is there anybody else interested in providing public comment on an agenda? I'm sorry, on an item not on the agenda. This is the general public comment time. Okay, seeing none, I will close the general public comment and we will move on in the agenda. It is noted for the record that regulations will be addressed one at a time in numerical order. Public comment will be taken in the same order, and public comment on a particular regulation will be closed before moving on to the next regulation. Before public comment is opened on each regulation, I will read into the record a summary of the proposed changes. today. We will start. All right, and the workshop, I will now open the workshop regarding proposed amendment LCB file number R099-21. Okay, R099-21. Existing law, Existing law requires each county and city clerk to send to certain registered voters a mail ballot for every election. The county or city clerk is also required to enclose a return envelope with the mail ballot that is sent to a voter. This regulation requires each county and city clerk to 1, submit to the Secretary of State a request to use a unique color for all return envelopes that are enclosed with mail ballots in the county or city as applicable, and 2, on and after January 1st, 2024, print return envelopes in the unique color approved by the Secretary of State for that county or city as applicable. This regulation also authorizes the county or city clerk to print return envelopes in the unique color approved by the Secretary of State for that county or city as applicable before January 1st, 2024. At this time, I will open public comment regarding proposed regulation LCB file number R099-21. If you are interested in providing public comment on this proposed regulation, please indicate so in Zoom. Mr. Williams.
Thank you very much. Oscar Williams from Reno. Let me pull something up here, make sure I can read this thing. So let me set this up and then I'll ask you this question. And it kind of goes along the lines of what we were talking in the pre-stuff. It says existing law, sections 3, 4, 51, and 52 of Assembly Bill number 321. That's not a law. It says existing law and it's citing Assembly Bill. Do you think that's proper? Do you think that's the way it should be done, sir? Mr. Ott, do you have an opinion?
I'm sorry, Mr. Williams, are you done with your 2 minutes then?
That's it. It's a question. I asked you a question. I'd like an answer, please.
Yes, sir, absolutely. And more than happy to explain. If you scroll down, if you're looking at the text of Assembly Bill 321, it's 76 pages long. I just pulled it up on the legislative page. If you look down on page 73 of 76, you'll notice that it says this section and section 84.5 of this act become effective upon passage and approval. Section 89.5 of this act becomes effective on July 1st, 2021. Sections 1 to 84 inclusive, 85 to 89 inclusive, and 89 to 91 of this act become effective upon passage and approval for the purpose of adopting any regulation and performing any other preparatory administrative tasks that are necessary to carry out the provisions of this act, and on January 1st, 2022 for all other purposes. So yes, I'm confident in stating for the record that Assembly Bill 321 is part of existing law now. Does that answer your question?
That I was not aware of. I have downloaded those bills. I haven't read through them. They're lengthy and they're full of egghead stuff, and determining what is law, what's not law. That's extra homework that I haven't been able to do yet. But I will look at that, sir, and I thank you for that response. I yield. Thank you.
My pleasure. For everyone's interest too, I will put the link directly to the text and overview of Assembly Bill 321 in the chat for the record. Is there anybody else interested in providing public comment regarding proposed regulation 099-21? Mr. Beatles.
Yeah,
Yes,
just one quick thing here, just on the new section subpoint. There should be no fee to mail a cast ballot in the official pre-addressed and stamped envelope that's provided a registered voter who formally requests a mailed ballot. So we're going to need a cost estimate for that. That's it.
Thank you, Mr. Beatles. Appreciate your comments this morning. We'll take it into consideration. At this time, is there anybody else interested in making public comment regarding proposed regulation 099-21? Check the chat. So the question I see in the chat from Ms. Brock regarding the payment of the envelopes, printing, postage, and other costs. So Assembly Bill 321, actually just above the page that I just referenced, if you look on page 72, actually, this is specifically section 89.5. It describes the funding allocated to the Secretary of State to cover the costs of ballot stock, postage, and postcard notifications to carry out the provisions of this act in the following sums. It says 6.2 million for 2021 to 2022, and that's fiscal year 2021 to 2022, and 5.9 million for fiscal year 2022 to 2023. That funding was appropriated by the legislature and is intended to go, again, as the counties are ultimately the ones that pay, the counties will be reimbursed for their expenditures regarding ballot stock, postage, and postcard notifications. If there's no other public comment intended for proposed regulation 099-21, I will close public comment. And we will open the workshop on proposed regulation R100-21. R100-21. Existing law authorizes certain persons to demand and receive a recount of the vote at an election. A person who demands a recount must deposit in advance the estimated costs of the recount. If the person who demanded the recount does not prevail and it is found that the sum deposited was less than the cost of the recount, the person is required upon demand to pay the deficiency to the county clerk, city clerk, or secretary of state, as the case may be. If the sum deposited is in excess of the cost, the excess must be refunded to the person. If the person who demanded the recount prevails, the sum deposited with the secretary of state, county clerk, or city clerk must be refunded to the person. Existing regulations provide that 1, a person who demands a recount of votes may withdraw the demand by filing a withdrawal in writing before the completion of the recount, and 2, the county or city clerk must stop the recount as soon as practicable after such a withdrawal is filed. This regulation provides instead that 1, a person may, before the completion of the recount, file a withdrawal of the demand in writing with the officer with whom the person filed the demand, and 2, each county or city clerk who is conducting the recount must stop the recount as soon as practicable. If it is found that the sum deposited for the purpose of the recount is 1, less than the cost of the recount at the time of the withdrawal, the person must pay the deficiency to the county clerk, city clerk, or secretary of state as applicable. Or 2, in excess of the cost of the recount at the time of the withdrawal, the excess must be refunded to the person. At this time, I will open public comment regarding proposed regulation LCB file number R100-21. If you have any interest in providing feedback regarding this proposed regulation, please go ahead and indicate so in the chat. Mr. Beatles, please.
Yeah, just a couple quick points. We should add a new section that says all recounts will be performed by the county appointed audit board. This requires the formation and funding of an audit board. So what we need is a bipartisan. It needs to be made up equally of Republicans and Democrats with citizen oversight. Also, all recounts need to be by paper ballots by hand. We can't be looking at envelopes or these cast images or any of that stuff. They need to be the actual physical paper ballots in hand. That's all.
Thank you, Mr. Beatles. Ms. Thomas, please.
Good morning. Again, I think any and all reference of persons needs to be changed to citizens, as citizens are only allowed to be participating in our election process, and there should be no room for misinterpretation or misuse by Russians or Chinese coming in to try to disrupt our election process by implementing this appeal process. It should be by the citizens only. Thank you.
Thank you, Ms. Thomas. Is there anybody else interested in providing public comment regarding proposed regulation with the LCB file number 100? Okay, if not, then at this time I will close public comment on proposed regulation LCB file number 100 and open the workshop on LCB file number R101-21. Okay, existing law 1 requires a county clerk to cancel the voter registration of a person upon the determination that the person has been convicted of a felony and is currently serving a term of imprisonment. 2, provides that a person convicted of a felony who has served his or her sentence and has been released from prison is immediately restored the right to vote. And 3, authorizes any such person to re-register to vote upon release from prison. Existing regulations provide that the Secretary of State will immediately provide the county clerks with any information the Secretary of State receives from the Attorney General of the United States regarding the conviction of any person of a felony. Section 2 of this regulation provides instead that the Secretary of State will immediately provide the county clerks with any information the Secretary of State receives from the Attorney General of the United States or the Department of Corrections regarding any person who is convicted of a felony and sentenced to a term of imprisonment. Section 2 also removes obsolete language related to the former process of restoring the voting rights of a person who is convicted of a felony. Existing regulations require a county clerk to count a provisional ballot under certain circumstances, including that a voter has not been convicted of a felony, or if the voter had been convicted of a felony, the civil rights of the voter had been lawfully restored. Section 1 of this regulation removes this obsolete language in order to comply with the applicable provisions of the Nevada revised statutes. At this time, if anybody has interest in making public comment on proposed regulation LCB file number R101-21, please go ahead and indicate so in the Zoom screen, or raise your hand, please. Mr. Beatles, please.
Yeah, I don't want to get into the debate of whether a felon should vote or not vote. You know, if the prison system works, then it'd be reformed, right? But we could change the wording at least to where you have NAC 293.270 to where it says if the voter did not show proof of residence and identity at the time he or she registered to vote, the voter shall be denied a ballot. That's all I got. Thank you.
Thank you, Mr. Beatles. Ms. Thomas, please.
Again, I would suggest that any reference to person be changed to and corrected to citizen, because not all people that are released from our prisons are citizens. Just by the mere fact of them being released from our prison does not mean that they get to and are entitled to register to vote. This could be misused again. And to speak to Mr. Beatles' point, there is a law that states that if those things are not verified, they are not to be issued a ballot. But not all the things are being verified, as was clarified that citizenship is not being verified.
Thank you, Ms. Thomas. Ms. Dermott, good morning.
Mark, it's good to see you. Thanks so much for putting this hearing on. I really appreciate it. So I'm representing Albany's Local Action, and I would like to, we could see in Section 3, specify that a person re-registered upon release of prison does not need to prove their eligibility. The submission of registration form with the sign attestation to eligibility on that form is sufficient for registration. The registrars may not use the same source of information listed in Section 2. The ones they can use to cancel registrations to reject a registration form. And then one other suggestion is if we could add a section that provides guidance to the Department of Corrections and the Department of Parole and Probation on informing previously incarcerated voters on their right to vote. Thanks so much.
Thank you, Mr. Dermott. Good morning. Mr. Parks, good morning, please.
Bruce Parks, Chairman of Washington County Republican Party. I would recommend you remove any language that uses the term automatic. When you commit a felony in our state, you forfeit your rights as a citizen. To restore those rights should require an application process. Thank you.
Thank you, Ms. Parks. Ms. Lee, good morning.
Good morning, Ms. Velasco. Pauline Lee from Clark County. This is actually a question posed to you. Does the Justice Court clerk submit the information about the conviction to the registrar? In other words, how is the information conveyed? And also, is there if there is an appeal, how do you treat that with respect to canceling their voter registration?
Ms. Lee, thank you for the questions. So one, to start with the Department of Corrections, this is a process that we're actually working to improve upon, very similar as we've done with the process with the Office of Vital Statistics, where currently the Office of Vital Statistics provides a nightly document to us through an electronic secure means that we're able to validate that list that they provide of individuals who have died in the last 24 hours against the statewide voter registration list. Something similar is being worked on currently with the Department of Corrections, so that we can ensure, again, the trigger for the law is they have to be convicted of a felony and imprisoned. So those individuals who meet those criteria are the ones that we're looking for the DOC to provide information upon in a very similar daily basis to improve the consistency across the state, so that it's not necessarily dependent on a single clerk in one location or another to make sure they're notifying their respective election officials. Does that answer your question?
Yes, so it is nightly. So all of the information would be conveyed to the Secretary of State nightly. Okay, and then the other question is if in fact they filed an appeal, so they continue to be incarcerated. How is that treated?
So the appeal process, and I apologize, that was your second question. So we treat it again very similarly as we do really, with a lawsuit. We follow the statutes until a judge tells us to pause or stop following the statutes. So there's a certain point where the appeal process, once the appeal is finally adjudicated, that's the determination that would then alter whatever the county clerk is doing regarding to that individual's registration.
Great, thank you for your clarification.
Yes, ma'am. Miss Mary F., please state your name for the record, please, and the floor is yours.
Hi, Mary Fisher, Nye County, and I was a poll observer for 3 weeks. And I just want to say that I thought it was interesting that the legislature accepted the allowing felons to have the right to vote, and also people in jail who have not been convicted yet the right to vote. And in August of 2020. So I thought that was kind of underhanded, and how they slipped these kind of things right before the election. That's all. Thank you very much. I appreciate it.
Yes, ma'am. Thank you. Mr. Camp, good morning.
Good morning, Mark Camp, candidate for Nye County Clerk. As a Republican, my concern about this and other regulations is the proof of residency requirements. Right now, anyone can go to the DMV online or in person and not provide any legitimate proof of their residency in any county or district. All they need to do is say that they live there, and that is accepted. This then is also used then for registration to vote through the motor voter process. Again, no true proof of residency is required. And my concern through this and any provisions is that the voter registration process in Nevada and the DMV registration process in Nevada is weak at best, which then makes any of these other provisions just as weak, because someone can say that they live somewhere at any address and there's no further follow-up and no additional evidence other than their affidavit that that is the truth. Thank you.
Thank you for your comments. Is there anybody else interested in providing public feedback regarding proposed regulation with the LCB file number R101-21? If not, then I will close public comment at this time, and we will open public comment on proposed regulation R012-21. Existing law requires that it requires a registered voter to challenge the right to vote of another person if one, he or she is registered to vote in the same precinct as the person whose right to vote is challenged, and two, the challenge is based on the personal knowledge of the registered voter who submits the challenge. The challenge must, one, be signed and verified by the registered voter who submits the challenge, two, name the person whose right to vote is challenged, and three, name the ground or grounds as applicable of the challenge. Existing regulations require any such written challenge to be on a form prescribed by the Secretary of State and contain certain information, including one, a statement of the facts upon which each ground for challenge is based, and two, a statement that the challenge is based on personal knowledge of the facts upon which each ground for the challenge is based. This regulation requires that a written challenge also contain any documentation or evidence supporting the facts upon which each ground for the challenge is based. Existing law provides that if a written challenge to the right to vote of another person is filed and a challenged person applies to vote, an election board officer is required to tender the challenged person an oath or affirmation. The oath or affirmation is required to be in a certain form depending on the reason set forth in the challenge. If the challenged person executes the appropriate oath or affirmation, he or she is allowed to vote. If the challenged person does not execute the appropriate oath or affirmation, with certain exceptions, the challenged person must not be issued a ballot. Existing regulations require that the oath or affirmation of the challenged person must be on a form prescribed by the Secretary of State and contains certain information, including one, a statement of the facts upon which each ground for the challenge is based, and two, a statement that the challenge is based on personal knowledge of the facts upon which each ground for the challenge is based. This regulation requires that the oath or affirmation also contain any documentation or evidence supporting the facts upon which each ground for the challenge is based. At this time, if there's anybody, I'll open public comment regarding proposed regulation R102-21. If there's anybody interested in providing public comment on this proposed regulation, please go ahead and indicate in the Zoom. Perfect. Ms. Fisher, please.
I'm sorry, I forgot to, I'm new at Zoom, so I've got to figure out how to take my hand down.
Yes, ma'am, I understand completely. Mr. Kampf. Mr. Beatles, do you mind?
Yeah, what's up, Mark? All right, so this is, this section here is just really arduous. So we've done canvasses across, Nevada. We've done them across Washoe County. Initially we found 38 to 42% inaccuracies within the voter rolls, which is astronomical. Now we're pushing over 50%, meaning that our voter rolls are complete trash. And the way that this stuff is set up right now is that you need somebody from that precinct, all right? So somebody from the precinct where that address is in contest to basically sign an affidavit to attest to the fact that that person that's receiving a ballot shouldn't be. Well, that's kind of ridiculous in itself. I mean, it should be somebody that's from the state or somebody that's from the county, because the process you guys have right now is where you need somebody from the precinct to sign an affidavit and then submit it to the county clerk that then submits it to the DA that then submits it, back and forth between all these other people. They send out notices, and if they don't respond via notice, they're supposed to take them off the voter rolls. But one of the catches in there is if they show up to vote, then they stay on the voter rolls. So if you have a fraudulent system that essentially just uses, people to vote as that state or actor as sees fit, there's no way to remove these people from the voter rolls because they're always going to vote, even if it's a vacant lot. It's really ridiculous. So this whole process needs to be cleaned up. You need to allow batch processing of prima facie evidence of bogus registrations with evidence. For example, addresses not present on the county GIS maps or that are not in the county assessor's database of known residences and commercial government properties. These things need to be removed. Also, the above provision requires a new challenge form from the Secretary of State that allows for batch processing of prima facie evidence of bogus registrations with evidence. And the oath is cumbersome and unnecessary as the challenge form comes with penalties. If abused, penalties should be in bold print on the form. So we need to clean up this whole thing. ERIC is what you guys are using now, which appears to be literally registering every person, not voter in the state. So you got like 95%, almost 100% of the people that are in Nevada are going to be registered to vote. It's ridiculous. This is not what a free and fair and transparent election looks like. This has to change.
Thank you, Mr. Beatles. Appreciate your comments. again, just to clarify that this proposed regulation is unable to alter the statutes, specifically NRS 293.547. That's the one. If you look in part 2, subsection A, he or she is registered to vote in the same precinct. So that the precinct requirement is in the statute, not something that can be altered through regulation. But I do appreciate your comments, and we'll take the rest under consideration. Ms. Thomas, please.
Good morning again. Person needs to be corrected to citizens. Only citizens get to participate in this process. And I would like to know where the same day registrations are posted during early voting and election days so they can be challenged. Where are those names provided and what locations they've been voted at? So basically people who are doing same day registrations on those days, a provisional ballot is then cast into the machines. How are those provisional ballots linked to that voter who fails to provide the required documentation for completing registration? How do you pull that back out of those machines, and how do you link that ballot to a voter, a new registration? Because how does that make it a secret ballot if you can still connect that ballot to that voter if they do not provide the required documentation for completing registration? Thank you.
Thank you, Ms. Thomas. Appreciate your comments. Ms. White, good morning.
Good morning. My question is about the current or the new form that the challenges need to be made on. Is there a date when that new form is locked in so that there's not a new form provided, say, 7 days before, as I understand it, you have like 5 days or a limited number of days in which to submit the challenges. So if somebody decided to say that the new form is made available 6 days before, then it would be impossible to prepare thousands of challenges. So there needs to kind of be a solid, concrete date in which that form cannot be changed. So is there a date for that?
Excellent question. And the bottom line is no. Of course, given that, well, one, right, like there's a desire to make sure that the public's involved in the entirety of the electoral process. So that's something, you highlight a great point. While the form is under revision, I'm going to make a point to discuss this internally so that we're not, so that we're grandfathering the previous forms, so that, indications or maybe alterations to the existing form, again, ideally are done in a timely manner, but again, we'll allow time so that you're right. From an administrative standpoint, we're not trying to prevent anybody by any stretch of the imagination from submitting a form pursuant to NRS 547 or 303. Excellent point, though. And you did mention something that I think is worth clarifying as well. This is one of the potential amendments to this regulation that we're looking at. Is simply clarifying the submission window. At least for written challenges, NRS 293.547 right at the beginning says written challenges may be filed after the 30th day, but not later than the 25th day before any election. So one of the ideas under consideration now is clarifying that means before election day, which for the primary election coming up here in 2022 would mean from May 15th until May 20th would be the 5-day window. May 15th to May 20th would be the 5-day window, or 6 days technically, with the Sunday the 15th being again a weekend rather, but that would be the period for submission for a written challenge pursuant to NRS 293.547.
Thank you for that clarification. And does it mean, at 12:01 a.m. on May 15th, or is it business hours, May 15th?
Again, excellent question. Specifically, it's not defined, at least the beginning. Typically, it is business hours. I know for the due date on the 20th, that Friday, the last day, that will conclude at 5 p.m. And then this is something, again, the entirety of this process is something that clerks and I have discussed pretty routinely. I believe there's a number of clerks who are considering opening on Sunday the 15th, specifically to allow submission of written challenges. As you identified, this is a mere 2 weeks before the start of early voting. There's a lot going on, right, from an administrative and sort of point of view. Like the clerks are not going to have a lot of free time, so the goal is to make sure that these written challenges are addressed properly and pursuant to the applicable statutes and regulations. So I don't have an answer specifically by county right now as who's going to be open on Sunday the 15th, but I will make a note and be sure to put that on our website. And I'll even throw the link where we are going to post that information. All of our 2022 election information is going to be on the same site. So that way, if you do have questions later on down the line, by all means, please look here. And as we continue to update that, you'll see the information. I appreciate your comments.
A revision of that challenge form could have a chilling effect as well if additional demands for evidence are included that, you know, if it widely differs from the previous form. So, I mean,
yes, ma'am. It's not, again, the goal is to allow for, if there is evidence, to include it in the process. So yeah, the bottom line, it's not going to say, well, you haven't provided, you know, that there needs to be, you know, X number of pages, for example, of detailed information. The requirement in regards to evidence is intended to remove hearsay, so that we're not getting, you know, people saying, well, I saw somebody on social media and I just got a feeling that somebody is ineligible. The right to vote is something that we take very seriously, and the Secretary, again, is very much interested in making sure that legal voters are allowed to vote in the same sense that she wants to make sure that illegal voters are not allowed to vote.
Okay, thank you.
Yes, ma'am. Mr. Parks, please.
My question is, when we bring 40,000 challenges to the voter registrar's office on the very first day of this 5-day window, they don't have the personnel to investigate adequately all of the information that they will be inundated with. What are the preparations being made to handle such a huge amount of challenges, if any?
Thank you for comments and your question. I will, again, briefly touch on it. One, this is something that all of the county clerks and registrars are, again, aware of. Their preparations include, but are not limited to, making sure that vacant positions are filled, right? That by itself increases the number of people who are able to focus on this. There's plenty of discussions that are ongoing about the process and the procedures. There was discussions about making sure, like I mentioned a moment ago, that they will be available to receive these so that they can process them in a timely manner. You know, and even, you know, just from a practical sense, right? Like when you think about what is a clerk or a registrar going to physically do when they receive a stack of maybe 40,000 written challenges pursuant to 293, NRS 293-547. You know, step one is, of course, to confirm the information on there. Make sure that the challenger is in the precinct as is required by statute. And then really the second part, and I suspect this may reduce somewhat the number of individuals who this applies to, but check to make sure that the person being challenged is an active registered voter. If they're inactivated, if they've moved, if they've been canceled because they passed away or otherwise canceled their registration when moving out of state, for example, then the challenge is ultimately moot at that point, right? Because they, again, are not an active registered voter, would not have received a mail ballot. It does not mean that they cannot, you know, still vote, frankly, right? Because if someone's inactive, maybe that piece of election mail came back and now the individual moved across town, maybe is somewhere else in the precinct or else in the county or in the state. If that individual goes to the polls on election day, shows a driver's license and does same day registration, they still will be able to vote, which is an important thing to note also, because I don't want, well, the bottom line is submitting a written challenge does not mean, it's not a guarantee that an individual won't vote legally in our elections. But those are some of the preparations being made by the clerks and registrars. But thank you for your question and comment.
Well, my concern is not the people that will be voting legally. My question pertains to those that, for instance, have a registered, a valid registration, but their address that's listed is a vacant lot. They're still going to receive a ballot. That's just one example of many.
Yes, sir. Thank you for your comments. We'll take consideration. Ms. Benson, good morning.
Hi there. Good morning, Mr. Lashen. So I'm Alita Benson, political director, Nevada Republican Party. And I know we have a serious concern with you saying that the challenge form submission would be May 15th because the election starts April 30th when ballots get mailed out. Obviously, the longer timeline for ballots is it's changed the way elections are run, right? They used to be one day, then early voting started, and they're 2 weeks. And then now that we have absentee ballots, which are now all mail-in ballots, thanks to AB 4 and AB 321, the election starts at the end of April. So Clark, and I put it in the chat, Clark County has published their deadline for the start of ballots as being April 30th, 2022, which would put the submission deadline, the submission window for the primary to be March 31st to April 4th. And I know part of the reason that you know, when we were looking at, hey, if people know of something that's wrong in their precinct, the precinct captain or committee man, and they want to submit a challenge form, they want to make sure that somebody that they have personal knowledge that no longer lives in their precinct is not going to receive a mail-in ballot. And so that would necessitate it being having a challenge submission window prior to mail-in ballots being mailed out. So concerned to hear that May 15th was even a considered deadline, since according to from what I'm seeing in Clark, which is obviously 70% of the population, they are going to be mailing ballots out by April 30th for UOCAVA ballots. So just wanted to get that on the record. Thank you.
Yes, ma'am. Thank you for your comments. We did discuss this with LCB and our legal representatives. And the existing law is currently requiring the dates that I briefed and mentioned. But I will take your comments down and we'll have further discussions about it. Thank you. Ms. White? Ms. White, do you have a comment?
I'm so sorry. What actions will the voter registrars take to confirm that someone is an active voter besides comparing digital lists that you already have? Is there anything additional to that? And then the second thing is somebody showing up with the driver's license on voting day during the season. That doesn't really prove citizenship because DMV is not confirming and verifying citizenship. So you're using an unreliable document to document something very important as the right to vote. And then I know you just said that legislatively that's the season for challenging, but given the extension of the voting season entirely, it seems that challenge season should also have been extended. So for future recommendations to legislators, that should be, brought up definitely. And then as far as the dates of the season, one thing should be challenged. Again, I'm saying it should be far in advance, much more than 5 days. The point is to capture those addresses and those inactive or ineligible voters from even receiving a ballot. So all of this needs to happen before ballots are sent out. Otherwise, you're flooding the state with ballots that should never have been given out. And given what's happened in previous elections across the country, excess ballots and universal mail ballots are not helping with any kind of election integrity. Thank you.
Thank you, Ms. White. Just to clarify my previous comment, when the registrar reviews the challenge and compares the information of the voter being challenged to that county voter registration list, if an individual is on the challenge form and is already inactivated or canceled on the county list, they will not have been sent a ballot. So your concerns about that, I think, will be taken care of because, again, ballots will only be mailed to active registered voters. But in regards to the timelines, I appreciate the comment. I've taken note on it, and I'll be sure to include that for the discussion. Last thing, actually, while I'm thinking about it, you highlighted a great point. You commented for legislators, in regards to, suggestions. I wholeheartedly encourage all of you that when you're providing suggestions about something that really relates to a statute, a change in the statutes, please contact your legislators. They want to hear you. I've talked to a number of them about elections. And again, if you haven't had a chance to let them know your thoughts, that they're truly the ones that submit bill draft requests, the BDRs that ultimately influence our Nevada revised statutes. That is not something I have any ability to do, certainly. Secretary of State has a number of BDRs that she's able to submit. But again, your representatives want to hear your voice. And certainly this is the ideal time period over the next roughly 12 months, right, before we get to the February session in 2023. So please let them know. One last question, actually, Ms. Thomas,
I just wanted to clarify, is there a different section for challenging same-day registrations, or is that also included in this section?
So the two statutes that talk about challenges, again, as mentioned, 293.547, which is written challenges, and then 293.303 covers challenges in general. Some of that relates specifically to the written challenges in 547, but it describes that. Then additionally, there's some regulations in NAC 293. Those are, again, the regulations like we're discussing today. 416 and 418 are the two, I believe, that relate back to written challenges. And I'll tell you what, I will put those into the chat for everyone's, for convenience purposes. One moment, please. Okay, at this time, is there anybody else that has public comment regarding proposed regulation R102-21?
I do, Valerie White. And just to clarify, there is only that 5-day period in which challenges will be accepted. If somebody, the neighbor across the street or whatever finds out that somebody was registered to vote there, they couldn't go and challenge it any day except those 5 days. Is that correct?
If you're using the statutes 293.547, that has a defined submission window. But if you look at, again, NRS 293 section, 293.303 challenges, again, that has additional information that can be provided. There is actually, that's part of the section on challenges. So there are other opportunities and reasons if you wish to challenge somebody defined there in statute as well, including 304 and 30. What's the other one right before it? One second. There is 293.535 as well. That's the challenges alleging that a registered voter is not a citizen of the United States or is abandoned residence in county. 293.535. I'll put that one in the chat too.
Thank you.
Mr. Hindle, please. Good morning.
Good morning, Mr. Velasco. Thank you. Jim Hindle, Vice Chair of the Nevada Republican Party. Just from previous comments on the challenge window relative to the mail-in ballot deadlines for distribution, am I correct in that it seems as though the statutes are in conflict, or they're maybe not quite harmonized given AB 321 now? Because are we sending out ballots, mail-in ballots, prior to the closing of the challenge period or the closing for adjudication of those challenge periods? you're going to hear from me probably today that one of my key issues is that mail-in ballots are a primary source of potential corruption in our new system. And if we are not cleaning up voter rolls in order to make sure that mail-in ballots are only going out to legitimate legal voters and not being out in the wind, which of course we know they were in the past election in 2020, voter roll cleanup becomes a critical aspect of the integrity of our system. So if you could clarify those windows, that would help me. Thank you.
Thank you, Mr. Hindle, for your comments. I won't comment really in regards to if they're necessarily harmonized or not, simply just to state otherwise that yes, the answer to your question, will mail ballots be sent prior to the closing of the window for the written challenge period as defined in NRS 293-547? Yes, that is the case. The challenge period, again, really is up to its 30 days prior to election day, 30 to 25 days prior to election day. Mail ballots will be sent out for the military and overseas voters no less than 45 days prior to the election. And your county clerks and registrars are shooting for about somewhere between 30 and 45 days as well for their mail ballots being delivered in some cases.
So if I may, Mr. Velasco, just to follow up on that, I think that may be a key point that your office needs to take back to legislators, because we do need to harmonize in order to make sure we have integrity in the voter rolls to then have integrity in the mail-in ballots. So I think that might be a key point for you to make them look at. And, I know it's driven by statute as opposed to these regulations, but it seems to be out of balance right now.
Thank you for your comments, Mr. Hindle. We'll take it into consideration. Mr. Parks.
I just wanted to echo what has already been said. We're going to send out ballots before we have an opportunity to clean the voter rolls. Seems backwards to me.
Thank you for your comments, Mr. Parks. Also, a quick reminder in regards to a little bit on the federal and state laws as it relates to voter roll maintenance too. Just so that we're all on the same page too, right? There's a federal law requiring a 90-day blackout period for voter list maintenance. What exactly does that mean? And what is a blackout period? That means that 90 days prior to any federal election, you're not allowed to conduct routine state procedures that modify or alter your statewide voter registration list. That does not mean that we cannot cancel someone's registration if we find out that they're deceased. That does not mean that a voter who's moving out of the state can contact their registrar and say, please remove me, cancel my registration, I'm moving to a different state. Those individuals can still be removed from the statewide voter registration list. But 90 days prior to the election, again, the county clerks and registrars from that 90 days and then to the election are not allowed to conduct routine list maintenance. And just for clarity's sake, the maintenance of our statewide voter registration list is something that the secretary, the clerks, myself, and the entirety of the elections division take extremely seriously and have been working hard to make sure that we're not only doing it properly and following all the applicable state and federal laws, but that we're improving the systems and looking at new creative ways to make sure that our systems are done or maintained properly. And there has been significant improvements. Unfortunately, it's out of the scope of this specific regulation, but if anybody has any interest in discussing the processes that we take in an extremely detailed manner, I very much would enjoy talking to you about that. And we'll lay out all of the different things that occur at the state and county level to keep our statewide voter registration list as clean as possible. Again, please let us know, nvelect@sos.nv.gov, and we will certainly set up a meeting to discuss it with you and anybody else that's interested in understanding these processes as we take it extremely seriously. Ms. White?
Yeah, election day defined, is that, I mean, election day to me would be the date on which you can vote to elect someone. So given that the season is now beyond just a single day, it seems that the challenge dates should be based on when the election voting rights begin. And the second thing is the 90-day blockout, that's prior. And I'm just confirming, and it's going to be addressed, I think, in 103. Can the voter registration list and rules be altered after the election day, after the election season, you know, when they're extending them so they can count mail-in ballots? I'm not concerned so much about the dates. I'm just saying, once the election, I mean, that's what the 90-day blockout period, I think the purpose of it was to say, okay, these are the people who are eligible to vote. So there shouldn't be any alterations afterwards either. In some states, that was the problem. The registration rules were changed afterwards. All kinds of voters were entered into the registration rules. So I just want to know how Nevada is going to handle that. And the dates of this challenge have to be addressed. Thank you.
Yes, ma'am. Thank you for your comments. And I'll certainly add that on and make sure that, again, as you all amplify your concerns about the specific regulation, or more specifically the statute, I am capturing that as well. In regards to maintenance of our statewide voter registration list, it truly is an ongoing process with the exception of these 90-day periods. There are voters, again, this might surprise you, who are eligible Nevadan voters who register to vote and then the next day cancel their registration because they do not want to be on the statewide voter registration list. There's a number of reasons individuals do that. That's a legal process and is covered by statute so that an individual can register and then cancel their own registration after casting the ballot. In regards to maintenance of the list after election day, that continues as well. There are a number of individuals, when you look at the stats from the Office of Vital Records, I believe it was about 30 registered voters die, give or take, unfortunately, on a daily basis. Those individuals, as the process of their death certificate goes through and the registrar for vital records finalizes them and sends them to us, those individuals come off of our lists throughout the year, again, on a daily basis. There are other individuals who are turning 18, of course, shortly after Election Day and again, register as well. So in the same sense that we're a very transitory state, our statewide voter registration list is a very much living document. In the hour and 15 minutes that we've been on this in this workshop, I can guarantee there have been a number of changes at the county levels as people have passed away, hit their birthday, just decided to register to vote finally when they're ready to, again, identify that they're an eligible voter. So there's a lot of ongoing changes so that it's hard to get an accurate snapshot in real time that it's accurate for more than a few minutes, frankly. But again, the goal is accuracy in identifying our eligible voters, accuracy in removing those individuals who are not active anymore or should not be active, again, to the fullest extent of state and federal laws.
I'm sure you understand, though, how a changing voter registration list would hamper an accurate audit. That's the vital statistics, deaths and births in 18, et cetera. Those aren't the issue. The issue are fraudulent registrations that happen prior to election season and are removed after the election season. That's the issue. And I'd like to know how those are being addressed, because, I mean, if it's going to be a living document, then there needs to be a protected record of that voter registration list daily or hourly, so that should an audit be necessary, they could go back and capture that.
Yes, ma'am. I absolutely appreciate your comments. And I would very much like to discuss this matter with you further in depth to tell you the exact things that we're doing to cover exactly what you just talked about. There are some very positive steps that we're taking as a state and at the county level. Yes, ma'am. But thank you for your comments. Ms. Benson?
Hi, Mr. Lashin. I just wanted to add a point of clarification. When it came to the challenge form submission window, you mentioned that it was before Election Day, but in NRS 293.547, which is the section that governs written challenges, it says after the 30th day, but not later than the 25th day before any election, a written challenge may be filed with the county clerk with the criteria about how to file it. So I know, just, I wanted to clarify, it's not election day, it's any election, which would certainly, the way that I think most reasonable people would interpret it is when ballots go out and someone can have the ability to vote, since we all get mail-in ballots now. So just wanted to add that in there because it does not say election day. Thank you.
Yes, ma'am. Thank you, Ms. Benson, for your comments. Again, after discussion, this was not something we decided unilaterally. This was very much a discussion process, but I will take your comments into consideration and make sure they're expressed appropriately.
Yeah, Mark, can I weigh in just briefly on that point?
Oh, please, Mr. Ott.
Yeah, Ms. Benson, I think you've raised a good point. I just want to provide a little further clarity. That's a good distinction that you raised. And one of the things that came up earlier is whether the Secretary of State is trying to change the law or color outside the lines, right? And one of the checks on that is LCB saying, hey, this change that you guys have proposed is outside the law. So when we were looking at this section in consultation with LCB, we wanted to know how much freedom there was with regard to interpretation. And the exchange was basically that the day of the election meant election day, and that there wasn't freedom to change it to anything beyond that. So I don't want you to think that we didn't look at that issue. And as you know, the regulatory process is ultimately a creature that is a servant of the legislature. So when the LCB lawyers say, you guys can't make this change because it would conflict with the law, that sort of ties our hands on that. So I just wanted to provide a little further background on that.
Yeah, I know LCB weighs in, but it doesn't say election day. So that's okay. We will, that's probably a topic for another day, but I appreciate the perspective shared. Thank you.
Mr. Beatles.
Yes, great. So just curious, you guys mentioned a lot about the voter rolls and how important they are for you guys to keep clean. Curious, the 5-day window to challenge, do you guys consider that before the early voting starts or when the day of the election? If you could answer that real quick, and then I got one more for you.
Certainly, as defined in NRS 293-547 and recognizing the counsel that we received in regards to the definition of before any election, that's, I believe, a 2-week period or a period 2 weeks before the start of early voting, early in-person voting, which I think is what you're going to hit on. As Ms. Benson highlighted, is actually after ballots are sent in some cases. So people may have, in fact, been legally voting before or during that written challenge period. Okay.
And then if you guys are really concerned about cleaning up the voter rolls and taking it as serious as you said, again, we found 38% to 42% last year of the voter rolls in error, and now we're up over 50%. And now in 2020 and 2021, you guys have added 170,000 new voters. Are you aware of that? Where did they come from? Just curious. I'd love everybody to hear this. Where did the 170,000 people come from? And also, who authorized and gave you guys power to use ERIC within our state, which is funded by Soros?
A couple questions there, Mr. Beatles, that I think I could touch on, as I, again, believe they're relatively related to the regulation. So I'll stay true to that. So first, again, statewide voter registration list, living document, mentioned that before, very transitory state. And while I won't begin to go into the economic impact or the transient nature of our citizens or who decided to move to Nevada over the last 2 years that is of voting age, or why perhaps they decided to register to vote at this time. But there's a number of reasons. Again, we're here simply to enforce and execute Title 24 to the best of our ability and in compliance with the applicable laws and regulations. So as to why, I don't know. I haven't frankly polled 1.3 million people to ask why or who's moving here or who the new individuals are. I do know that if they're on our statewide voter registration list and identified as an eligible voter, it's because they met the statutory requirements.
Let me clarify. That 170,000 people over 2020 and 2021 was in Washoe County alone. We went from 150,000 registered voters to 320,000. How does that happen?
There's a number of ways that individuals, and I'll answer this and then I'm going to move on because I do want to get to some of these other regulations, but a number of ways that individuals are eligible and able to register to vote, either online or going to their clerk's office, or again, there's been an increase in the number of individuals courtesy of the automatic voter registration process that's underway at the DMV. So again, if you're interested in discussing the influx of new registered voters and locations and a number of other features, love to set up a call with you afterwards. We can certainly discuss everything from statistical changes over the last 12 months to some of the different tools that we use to track those changes to ensure that they are valid, eligible voters. But it's just unfortunately out of the scope of this regulation.
Who also authorized ERIC? It's funded by Soros. Why would we do that? And why they want to register 95% of all I guess just persons, not even citizens, 95%.
He doesn't actually fund it. It's paid for by the states. We pay it's dues based, which is really all I think I can say on that, because this regulation doesn't actually talk about the ERIC process. But if you're interested in the ERIC process, definitely eager to talk to you about that as well. A lot of merit it brings to the state in ensuring that our statewide voter registration list is accurate and clean from individuals in other states. Mr. Williams.
Hello. The issue of window challenges, it comes up again in R104-21P, just so you know. Okay, we'll have this discussion in a few more minutes.
Yes, sir. Thank you. Is there anybody else interested in providing public comment on proposed regulation R102-21? If not, then I will close public comment on proposed regulation R102-21, and we will move on to R103-21. Here we are. Okay, existing law requires one, that the county and city clerks to prepare and distribute to certain registered voters a mail ballot for every election. Two, requires the county and city clerks to check the signatures on received mail ballots. Three, authorizes each mail ballot central counting board to begin counting the received mail ballots 15 days before the day of the election. And four, requires each mail ballot central counting board to complete the count of all mail ballots on or before the 7th day following the election. Sections 1 and 3 of this regulation require each county and city clerk, as applicable, to report to the Secretary of State during certain periods: 1, each registered voter that has been sent a mail ballot; 2, each registered voter whose mail ballot has been received by the clerk; 3, whether the clerk has completed the process for checking the signature of a mail ballot; and 4, whether each mail ballot has been processed and counted by the mail ballot central counting board. Existing regulations require each county clerk to electronically transfer certain information to the statewide voter registration list at least once each business day. When a county clerk electronically transfers such information to the statewide voter registration list, the county clerk must certify that the county clerk has complied with such applicable technical requirements for security as may be prescribed by the Secretary of State to ensure the confidentiality of the information transferred. Section 2 of this regulation requires instead that when a county clerk electronically transfers such information to the statewide voter registration list, the county clerk must certify that the county clerk has complied with such applicable technical requirements for security as may be prescribed by the Secretary of State to ensure the confidentiality of the personally identifiable information transferred. At this time, I'm going to open public comment on proposed regulation R103-21. If you have any interest in providing public comment on this proposed regulation, please go ahead and indicate so. Mr. Beatles.
Sorry, come back to me if you would.
Sure thing. Ms. White, please.
Okay, thank you. I hope I'm reading this wrong. I read it earlier this morning. It seems to infer someplace in here, and I was looking for it just now, that when a county clerk receives a ballot, and I'm assuming it's a completed ballot, that the clerk is required to report to the SOS that person's identity and information, confidentially, of course, and then they're added to the voter registration list. Now, I hope I'm wrong, because just receiving a ballot does not indicate that they should be added to the voter registration list. Did I read that wrong? Please tell me I have.
You have read that wrong.
Okay.
Yes, ma'am. Again, ballots are only sent to active registered voters, so they will already be on the statewide voter registration list. The information that's getting transmitted in the requirement for increased awareness of the security of the personally identifiable information. Is really again, the part in section 1, subsection 2. In addition to the information required, each county clerk shall at least once each business day inform the Secretary of State whether the mail ballot of a registered voter has been processed and counted. The intent there, again, is increased transparency. A number of voters have identified that when they send their ballot through the mail back to the county clerk or registrar, they would like to know that it has been received in a timely manner. That requires the counties to notify the Secretary of State, this proposed regulation does, so that we can make sure that information is added to the statewide voter registration list. And that way you're able to check, what's the status of my ballot? Where is it? Okay, it's been received by the county clerk. So this is an increased transparency one. Does that clarify?
Yes, thank you.
Yes, ma'am. Ms. White, I'm sorry, Ms. Lee, please.
Good morning again. So I have two comments, and one is that you are creating, or rather, it's a somewhat audit of the voter rolls. In other words, you are taking a list daily of the registered voters, including those who received mail-in ballots and those for which the county clerks have received ballots. However, I'm also proposing that you also add that there should be a count and a registry of those returned mail ballots because the voters have changed residency. That way you can actually confirm that they should be taken off the voter rolls. That should be added because if you have all of these ballots coming back that says return to sender, I suggest and propose that that should be known by the Secretary of State. Secondly, with respect to voter receipts, we had a big problem during the November 2020 election where people would look onto the Secretary, they would go onto the Secretary of State's website to confirm that the Secretary of State or county clerk had received the ballot. And what do they did when their name was not there, or they could see through the website that their ballot was not received, they had no recourse. So the question is, why can't we have voter receipts or some kind of a confirmation given to that person that says, hey, I did vote either by person or by mail ballot, primarily the ones in person, so that they can confirm and there is some recourse if in fact the Secretary of State has not recorded their ballot.
Ms. Lee, thank you for your comments. That is something, again, that we'll take into consideration, but it's also something that you're absolutely right. We are looking very closely at. I will say that at least as the as-is process, if a voter submits a mail ballot and it has questions about it, that the county clerks oftentimes have more accurate day-to-day information. Again, there's a bit of a lag. Again, it's a nightly document that is provided to the Secretary of State. So I encourage folks to reach out to their registrar. It is also possible that if an individual votes by mail, a day or two goes by and they're concerned that that ballot may not get to the clerk or registrar in time, you can contact your clerk or registrar, ask that the mail ballot be canceled, and then vote in person. So that even if, as the ballot works its way through the mail stream, it is possible to have the clerk invalidate and cancel that so that it will not be counted as a second cast ballot. And you are able to cast your ballots in person at the registrar clerk's polling locations. Yes, ma'am.
No, but what is the recourse if in fact you believe you voted either in person or by mail and it is never recorded, 2 weeks later or, a week later, it is not recorded. There is no recourse.
No, ma'am. You're absolutely right. And I'll tell you that happens too. There's a number of cases that happen every election too, where the ballot arrives, and this happens, and it's happened with absent ballots for years, so long before the 2020 election cycle. Mail ballot arrives at the clerk or registrar's office. They review the signature, compare it to the statewide voter registration list to make sure that voter's signature matches. Once it's confirmed, they move it to the next step in the process where they open the ballot to separate it. And there is no ballot. They receive empty envelopes. That happens a number of times. And in those cases, exactly, I think, as you imagine, the voter would say, I sent a ballot and I know for a fact I mailed something in. But again, when there's no ballot in there, or in some cases, clerks and registrars have received primary ballots during the general election, which of course don't count. Those sort of situations do arise every election. And it's something, again, that we take seriously, that we're looking at and trying to identify means that we can notify a voter. But you're right, ultimately there is a level of voter frustration when those sorts of incidents occur. So that's something we're trying to continue to get our hands around.
Thank you.
Yes, ma'am. Ms. Thomas.
Thank you. On section 2, the NAC 293.458, item number 2, when a county clerk electronically transfers information to the statewide voter registration list pursuant to subsection 1, the county clerk must certify that A, the information is accurate and complies with relevant state and federal law. What will the clerks and or registrars be doing to certify that the voter registration list being transferred to the state consists of only citizens in compliance with the state and federal laws? And where is the procedure documented in these regulations? Since it has been confirmed that many non-citizens are on current voter rolls, what is being done to ensure only citizens are receiving mail ballots? Thank you.
Yes, ma'am. Thank you for your comments. Again, there's a number of steps that the clerks take to make sure a voter is eligible. We have discussed some of those concerns, but I'll take note of your comments and we'll certainly keep them into consideration. Mr. Beatles.
Yeah, thanks, Mark. You know, to address what Pauline said earlier, if you just go to operationsunlight.com, it shows exactly how to fix this entire mess with our petition, which is more of a manual on exactly how to make a free and fair, transparent election. You also have our comments in writing from Oscar, myself, and team. But I mean, when you just get down to the basics of these mail-in ballots, I mean, we know that, what was it, the Carter-Baker Commission said the #1 way to cheat is through mailed-in ballots, right? So, you know, if you look at our European counterparts, they don't do mail-in ballots, the majority of them. We should have election day, not election month. I mean, everything that we're seeing here is just a way to amplify fraud. I'm just curious, everybody here is against mail-in ballots. If you do a poll of the actual citizens in the state, they're against it as well. Why is the Secretary of State so dead set on using mailed-in ballots?
That's an excellent question, Mr. Beatles. And I will simply go back to, at the risk of sounding a bit like a broken record, NRS 293-124. Secretary of State shall serve as the Chief Officer of Elections for the state. As Chief Officer, Secretary of State is responsible for the execution and enforcement of the provisions of Title 24 of NRS. The Secretary of State follows the laws. She does not pick and choose which ones to obey or enforce.
Well, I mean, we're changing regulations right now. Why don't we make this actually worthwhile and change the regulations to where we don't do mail-in ballots anymore? And then we could, you know, get your commission to vote on it, just like you're asking us to do for all this nonsense. And then we wouldn't have mail-in ballots anymore. Why don't we do that instead? That's what the people want.
Unfortunately, that's not part of the regulatory process. Regulations cannot conflict with the existing statute. So if there was a proposal from any agency that conflicted with the statutes, it would not get through the regulatory process. The statutes have supremacy over regulations.
Where did all this stuff that we're talking about come from then? Why don't we just change it to get rid of mail-in ballots? And you're going to have a vote on this on February 24th.
I encourage you to attend the Legislative Commission to provide your comments then as well, sir. But again, right now we're following the process as it's identified to receive public comment about these regulations that supplement and do not supersede the regulation or the statutes. Ms. Dermick, please.
Yeah, hi, this is Carrie Dermick with All Bodies Local Action. And I just would like to say that my organization and myself, we're fully behind automatic vote by mail in Nevada, and we appreciate the hearing and the comments.
Thank you, Ms. Dermick. Ms. White?
Would you please put in the chat the details for the February 24th meeting, the links and all of that stuff so that we can attend times, et cetera? Thank you.
Yes, ma'am. I don't know if the Legislative Commission, I've provided the link a minute ago to their website. Again, they don't fall, of course, under the Secretary of State. I have not yet been made aware of the agenda or timeline for that meeting. I have heard that they intend to have a meeting sometime during either the last day of business day of February is a Monday, either on the 28th or the week before that. But I do not currently have those details. They will post them on the site I just put into the chat, as well as
And what is the official title of this commission?
The Legislative Commission.
Legislative Election Commission? Legislative?
No, ma'am. Legislative Commission. They cover. It's an interim committee, and without going into much detail again, because that's completely out of the scope of my understanding. It's a legislative body that is set up of elected officials. But if you look at the link I provided, it does have some points of contact on there who will be able to provide you additional information about LegCom. Yes, ma'am. Is there anybody else interested in providing public comment regarding proposed regulation Rs 103-21? If not, then I will close the public comment on proposed regulation R 103-21 and open the workshop on R 104-21. Perfect. Okay. Proposed regulation LCB file number R 104-21. Existing law requires the Secretary of State to 1, establish and maintain a statewide voter registration list, and 2, enter into a cooperative agreement with the State Registrar of Vital Statistics concerning the death of residents to the state to maintain the statewide voter registration list. Existing regulations provide that on each business day, the Secretary of State will compare the statewide voter registration list to the vital statistics records maintained by the State Registrar of Vital Statistics. If the Secretary of State determines that a registered voter is indicated as deceased in the vital statistics records, 1, the Secretary of State will notify the county clerk, and 2, if the county clerk determines that a voter is deceased, the county clerk must cancel the registration of the voter in the county's computerized database of voters in the statewide voter registration list. This regulation provides that the Secretary of State will determine on or before February 1 of each year whether each county clerk has indicated in the county's computerized database of voters in the statewide voter registration list that the registration of the voters in the county that are indicated as deceased in the vital statistics records have in fact been canceled. At this time, I will open public comment on proposed regulation LCP file number R 104-21. If anybody is interested in providing public comment on this proposed regulation, please go ahead and indicate so. Mr. Beatles.
Yeah, on this one right here, you have our emailed comments as well, but something we should address here is this needs to happen more than once, right? I understand you said that they're constantly checking in daily or something like that, but these audits, these checks, they need to happen, like October 1st as well. And also, I mean, if it works so well, I mean, I think just in Clark County, there was 1,506 votes that were from deceased voters just in Clark County, if I remember right, from the GOP data that they had. So we definitely need to make sure that every legal vote is cast, and 1,506 votes just from deceased in Clark County, that should be alarming, not to mention what it was across the state. So we should definitely have more than the checks and balances that we currently have, and definitely strengthen this up.
Mr. Beatles, thank you for your comments. For what it's worth, that information is not accurate. I personally reviewed the number of individuals who have vote history that were deceased from the 2020 general election. It is not 1,500 in Clark County. If you're interested in discussing that at a later time, though, I would love to sit down with you and talk about our work in regards to ensuring our statewide voter registration list is clean, and that we have made sure that deceased individuals are removed in a timely manner, consistently and throughout the year, just like you, I think, indicated. But I appreciate your comments, and we'll certainly take it into consideration.
Yeah,
I'm sorry?
Yes, happy to share it with you.
Perfect, thank you. Mr. Parks, please.
Yeah, I would like to echo what Mr. Beatles is saying. only once a year and in February. So that allows for a person that is deceased in March to receive a ballot. I see a problem with that.
Thank you, Mr. Parks, for your comments. Again, just to clarify that this regulation does not mean that we only check for deceased individuals once annually. The check for deceased individuals occurs every single day. When the Office of the Secretary of State receives that information from vital records, we transmit it to the counties and they address it every single day. Again, business day, I should clarify. So that is something that is ongoing. This regulation specifically talks about receiving confirmation from the clerk that it has occurred once a year. But again, I think Mr. Beatles, in your comments in regards to increasing the frequency of those required validations, that's how I took it as notes, and I will convey that and take it under consideration.
And it's still, for whatever it's worth, Mark, it still relies on the Bureau of Vital Statistics putting the information on in their paperwork in a timely manner. You see the problem, I'm assuming here.
Yes, sir, and I understand that, and I think you're hitting the nail on the head here too. That not that it's an issue necessarily that vital statistics is somehow. I don't want to suggest that they're by any means negligent or not moving in a timely manner. I've learned a lot about this process and the issuance of death certificates as I've dug into it with my team. For example, again, when an individual passes away, oftentimes, if they were perhaps homeless, or even if they weren't, their family members struggle to find their social security numbers that maybe aren't frequently available. That delays the process. And there are amendments to death certificates that occur also. Those amendments, continuously happen, and making sure that the one that we receive, again, is timely is absolutely a concern across the board. But yes, sir, I understand your concerns and will convey them appropriately. Thank you. Mr. Hindle, please.
Yes, thank you, Mr. Velasco. Again, Jim Hindle, Vice Chair of the Nevada Republican Party. I want to echo some of the statements just made before me. Again, clean and accurate voter rolls are critical in a system employing mail-in ballots. And with the adoption of AB 4 in 2020 and now AB 321, inaccurate voter registration rolls is now a primary tool for corruption in our system unless we are vigilant in making sure that these voter rolls are accurate. And I know you talked about the process that the Secretary of State's office is going through in this. I think it is critical that we put a very high bar of expectation on our county clerks and, more importantly, on our registrars of voters. So we know that the vital statistics data is highlighting people that are passing away, moving, et cetera, but specifically those that are passing away. And that is happening daily, as you highlighted. To only have a specific deadline one time a year, I think is very risky, and it opens the system up for abuse. We saw in 2020 where a registrar of voters, through a excuse my inflammatory language, but was incompetent in cleaning the voter rolls and missed the deadline such that voter rolls were changed inside the 90-day window. We cannot have that happen on a regular basis, and there has to be teeth in the regulation that really requires these registrars and clerks to communicate and verify with the Secretary of State's office that they are cleaning up the voter rolls, and we recommend it at least monthly, and that they are confirming with you that they are taking these actions and confirming the actions with the Secretary of State's office and on public record. The subsection that creates a deadline of on or before February 1st of each year is just too loose and is not specific enough. We understand that there are deadlines that need to be met, but instead of the arbitrary deadline of February 1st, it should be in accordance again with the National Voter Registration Act that you highlighted earlier in our conversations today, which allows for voter roll maintenance to be, that has to be done within that 90-day window. In order to make sure that we are cleaning up our voter rolls prior to that requirement, I believe that the Secretary of State's office needs to mandate that the registrars and the clerks are reporting to you monthly that they are confirming and taking care of this voter roll cleanup. Please review and revise this section accordingly. I hope you'll understand the critical nature that we are putting on this. Thank you.
Thank you, Mr. Hindle. Appreciate your comments. We'll definitely take that under consideration. One moment, make sure, let's check the chat. One clarification from Ms. Brock. Again, the National Voter Registration Act of 1993 is the document that I was referring to earlier that talks about the 90-day blackout period. Section 8 specifically talks about maintenance in the blackout period, but that again does not require that you can't, or I'm sorry, it does not state that you cannot prevent the removal of deceased individuals or individuals who have requested their removal. So that 90-day period does not apply, the blackout period does not apply to deceased individuals. Okay, Ms. Thomas, please.
Okay. In the SOS's examination of vital statistics, the SOS should also maintain a database of birth records for the purpose of verifying citizenship by either the members of ERIC, or it would also be beneficial if the SOS would reach out to the U.S. Department of Homeland Security or encourage ERIC to, since they are one of the founding members of ERIC, to coordinate and develop an e-verify system for elections similar to the one used for employment verifications. It's my understanding that ERIC was used basically solely for verifying cross-registration in other states when they get a registered person registering to vote, that they notify other states that that person was previously registered to. However, since a section needs to be added to address cleaning the rolls from non-citizens. Thank you.
Thank you, Ms. Thomas. I appreciate your comments. We'll take into consideration. Ms. Lee, please.
Thank you. I can't underscore enough what Jim Hindle said about the once a year verification, that there's been a transmission of information from this registrar of vital statistics to the county clerks. Once a year is insufficient. Even for this year, 2022, we are expecting a primary and a general election. And it says on or before February 1st of each year, there's supposed to be a determination as to whether or not the county clerk had in fact made the transmission via computerized database. So even for this year, we will have, quote, missed the February 1st deadline. But more importantly, if there in fact has not been a transmission, we are relying on electronic transmission via computer. So we're talking about a lot of data that's being transferred. If we find out a year later that in fact the data was not transmitted, that's a lot of data that needs to be verified. So it makes more sense to do it monthly, because in fact, if there was not a monthly transmission, then you could check it by hand. You could actually eyeball it and actually determine why there was a mistake in the electronic transmission, or there was some kind of problem with the computer transmission. So monthly makes sense. Secondly, what if the clerk persists on non-compliance? There is nothing in this regulation that says that the Secretary of State will somehow do something, or that the county clerk has a certain amount of time to cure their failure to actually have made the transmission. And what if the transmission is because the computer wasn't working, there was a server problem, there was a blackout? There's a lot of things that can happen to computers. And so I think this regulation does not go far enough. It needs to, number one, make sure that the transmission verification is monthly. And then secondly, there has to be a backup or some kind of an effect or some kind of resolution if the county clerk refuses to comply or there is non-compliance. Thank you, Mr. Lashin.
Yes, ma'am. Thank you for your comments. We'll certainly take them into consideration. One item of note for your awareness. So I did mention that we received the information from Vital Stats Daily. I also have a standing policy with my team that if for any reason there's a disruption to the transmission to the counties of that information, that I will be notified about it. Again, alternatively, if there's a disruption to vital statistics, if on a random Tuesday throughout the year, they do not send us this file, I get a notification about it and I make a phone call because I just like I think as everyone is indicating, I don't want any gaps. I want redundancy. I want consistency in these policies and procedures. Again, the Secretary of State, not to sound like a broken record again, but 293-124, execution and enforcement of all laws, and that's federal and state laws relating to elections. If somebody doesn't comply with the statutes, there are a number of steps that the Secretary of State can take to ensure compliance. But yes, ma'am, I appreciate your comments and we'll certainly take them into consideration. Mr. Watson, sorry, yes, ma'am.
And then, because it says on or before February 1st of each year, how does that apply to this year? Because we're coming up to February 1st.
Yes, ma'am. So again, depending on when the regulations are implemented, again, if we've passed February 1st, then it will roll to the next year. Again, we'll continue to move on. There are things like this, though, where there's a possibility, and again, a lot of things going on right now, and don't want to commit to anything in the next 11 days, but if we're able to get that sort of confirmation, we'll certainly receive it in due course and post it in a timely manner. If these regulations are passed by the Legislative Commission, again, towards the end of February, again, we'll certainly consider and attempt to get that confirmation from the clerks and post it as well. Again, going back to, again, what we collectively, I think, have identified too is an importance of contributing to voter confidence that these policies, procedures, the statutes and regulations are being conducted and applied as proper or as expected. But yes, ma'am. Mr. Watson, good morning.
Morning. For the record, my name is Alex Watson. I'm the RNC's Election Integrity Director here in Nevada. Many of the proposed changes do the best they can within the constraints of Nevada law. However, the RNC has identified an issue with RO 14-21P that the Nevada Secretary of State's office needs to further evaluate. That being Section 1, subsection 3. Our concern, as you know, people pass away every single day of the year. County clerks now receive information from the Bureau of Vital Statistics on a daily basis. With the increase of information received from the Bureau, voter registration lists should be updated as often as possible. Moreover, the date of February 1st of each year seems arbitrary when the National Voter Registration Act, which allows for maintenance to be done up to 90 days before an election. Instead, we propose that getting rid of on or before February 1st of each year, the subsection should be revised to quote, on a monthly basis and within 90 days prior to any election. Thank you so much.
Thank you, Mr. Watson. Mr. Sakerson, good morning.
Good morning. Thank you for the opportunity. And I, at risk of belaboring this point, yes, the election rolls should be updated at a minimum on a monthly basis up until the 90-day blackout period. There's really no excuse for not doing that frequency. Thank you.
Yes, sir. Thank you. And again, just for clarification, statewide voter registration list maintenance does occur daily. And in fact, there's a publicly accessible statewide voter registration list that you can get through the bulk data download portion of the Secretary of State's website. If you download it right now and then check in 24 hours, you will notice significant changes as people move, arrive, register, get canceled, et cetera. But yes, sir, I appreciate your comments and we'll take them into consideration. Ms. White, please.
Thank you. You just answered my question kind of. I was hoping that you could give us the details for where we can access that publicly available voter registration list daily so that we can monitor what kind of changes are happening to it. If you could put that in the chat, we appreciate it. And then secondly, You mentioned the team again, and yesterday we talked about knowing who is on your team. Could we get that information? Could you please give me the official title of these individuals on your team, just so we know who's kind of responsible for these regulations? Thank you.
Yes, ma'am. Discuss that internally, and what we'll do here is two things. I'll get the link to the bulk data download site. I will put it into the chat for everybody so that you can see that. And then two, again, as it doesn't specifically relate to this regulation, I'm going to put the email address for our public information officer into the chat as well. In regards to a request for the organizational chart of the elections division, and that information, again, she'll be able to address and provide that again upon request.
Okay, so it's not something that I have to submit an NPRA for. The PIO will just give it to me.
If you reach out to her, yes, ma'am, she'll be able to provide that.
Okay, could you put her information in here as well and her name?
I will.
Thank you.
That's the email address for our public information officer, Mrs. Jennifer Russell. And then our bulk data download site, I just provided the link to that as well. There's a number of options and different types of information that you can actually request from the Office of the Secretary of State. There's a registration process too, just to make sure that we know who we're sending the information to. But by all means, go to that site, and then once you fill out the information, an individual on the team, Stacy, for what it's worth, will get your information and then provide details and instructions on how to request the information that you're after. And there's a number of customizable fields to make sure that you're getting the information you want. And there's, again, even non-elections related information that's publicly available on that site. If you have any questions about that site or how it works or what other information you can get, please reach out to mdelected.sos.md.gov. Also, put that in the chat, and that we'll be able to get back to you in a timely manner.
Thank you.
Yes, ma'am. Mr. Williams, please.
Hello. You mentioned a few minutes ago the issue of homeless people. We've done significant canvassing and research here on literally thousands and thousands of ghost addresses or addresses that are not valid mailing addresses, and yet they are registered to vote and ballots are being sent to them. Such as, for example, I'll give you two examples. One would be 0 Virginia Street and 2nd Street. It's a street corner, you know, and I appreciate maybe there's a homeless person there, but it's not a verifiable valid address. And we have no way of verifying that that was a real voter, or how to, you know, challenging becomes burdensome when you've got thousands and thousands of these. Now, the second example would be up in Gerlach. I think there's 37 people registered to vote in Gerlach, or no, sorry, 37 valid registered people to vote, but there's over like 50 that are there. So there's like a 75% puff of voters from Gerlach. And that's what's great about Gerlach is there's so few people, you easily identify, you know, and we're talking about, you know, undeveloped land up in the county between Nixon and Gerlach, and there's all these registered voters in the middle of nowhere. And so the numbers are huge. So when we talk about cleaning up our voter rolls and not automatically sending out ballots to every registered voter, I don't see that you guys are doing enough to weed out these invalid addresses, which could easily be found through the county GIS maps. That's how we're doing it. And we would like to be able to submit to the county or to the state our findings based on county mapping, prima facie evidence, if you would, that these addresses do not exist. And these voters are bogus. Did I pose my question right? I kind of posed a question in there, I think.
Yes, sir. I believe I understand your question and concerns. I do want to cite for your awareness to NRS 293.486, determination of an actual residence, specifically in here. And just to read it for the group, one moment. Except as otherwise provided in subsection 2 for the purposes of pre-registering and registering to vote, the address at which a person actually resides is the street address assigned to the location of where the person actually resides. For the purposes of pre-registering and registering to vote, the person does not reside at a location that has been assigned a street address. The address at which a person actually resides is a description of the location where the person actually resides. The description must identify the location with sufficient specificity to allow the county clerk to assign the location to a precinct. And then it goes on to say this provision, the provisions of this section do not authorize a person to pre-register or register to vote if the person is not otherwise eligible to pre-register to vote as applicable. So that, again, statute, the determination of actual residence, especially in rural counties, and having grown up in a rural county myself, you know, and I'm sure many of you are familiar, there are places that maybe you don't have a street address or a reference, you know, kind of past the second tree on the left. The point of that statute is making sure that the individual can be put into a precinct by the county clerk so that they're able to vote an accurate ballot based on their actual residence. I understand your concerns about the businesses, about vacant lots. That's also something, again, I'm not going to attempt to sugarcoat or say that, you know, dismiss it by any stretch of the imagination. There are a great number of things that we're doing at the state and county level to make sure that our state-wide voter registration list is accurate. But I do want to, again, at least highlight that, because that is one statute that has come up a couple times, at least over the last few months, and really after the 2020 election cycle, when people had questions about other individuals. So it's something that we take seriously, something we're continuing to look at and are not done yet with. But I appreciate your comments.
Well, sir, just to follow up, there's two parts to it. Is being able to show you really good evidence based on thousands of bogus addresses. You can clean up voter registration rolls based on that information. So we don't have to file one challenge piece of paper for every one of those, because there's thousands and thousands of them, and it's based on what I would like to call prima facie evidence of the county's GIS maps. If there's not a home there where somebody can actually live and receive a ballot, then you should remove that name from the voter registration. It's that simple.
And Mr. Williams, if you'd like to set up a meeting later on with me, I would very much like to talk to you about that information.
I'd love to. That would be great. Yes, you're really open and approachable, sir, and that's really nice. And I thank you for holding this and for being open and approachable.
My pleasure, truly. And again, the Secretary's guidance is very much this: to investigate every possible claim and to make sure that our lists are available. We don't assume that we're that we have a monopoly on the truth, or at least on the veracity of the different information out there. So please, yes, if you have information, I would like to see it.
Okay. Well, to follow up though, just to finish real quick, as it relates to R104-21P, again, and everybody's been saying this, we need more periodic, more open ability to file challenges. Why do we just have this little finite little window, which is so far away from the election, when you've got, you know, homeless people registering to vote that have no address, and maybe, you know, maybe they're just being bussed in that day. I mean, you guys have very liberal policies about presidential elections and allowing people to do same-day voting from out of state with no ID, and they could ship the homeless people in from Sacramento and get them to register to vote in the same day. And then who knows where they go after that? It don't matter. Their ballot has been cast, and now it's up to us to clean up the mess. Do you see what the problem is? We'd like to avoid that mess if we can, please. Thank you. I yield.
Sir, thank you for your comments. Mr. Kemp, please.
Yes, Mark Kemp, candidate for Nye County Clerk. One of the key pivotal points of this regulation is that it relies on the state registrar of vital statistics. I'm aware that in many counties, the process of sending out notifications to voters to identify those that should be inactivated is an annual process. So it is possible and likely that an individual could move to another state, stay on the voter rolls, and die in that other state. What provisions are being made in these regulations for the state registrar of vital statistics to coordinate with other states to get their death match statistics? Because someone can easily be on our voter rolls, move to Florida to get out of the communist state of Nevada and die in that state. Thank you.
Thank you, Mr. Kampf. Good question with an easy answer. When we talked to the Office of Vital Statistics, we made sure that they are not just sending us the information of Nevadans who die within Nevada borders. Surprisingly, or maybe not surprisingly, they actually send us the information of Nevadans who die anywhere in the country or in the world for that matter. So that if there are military individuals, for example, or overseas citizens who are Nevada citizens that unfortunately die overseas or in any other state, we get that information too, and have for some time. But I appreciate your comments and take it into consideration.
But just to follow up on that, excuse me, you said if they're a Nevada citizen. So are they only following up on Nevada citizens that have died in other states, or people who have actually gone to another state, registered there, but are still on our voter rolls and die in that other state?
So I think I understand your question, and let's see if I can make sure I'm accurate in explaining. There's a number of processes that would prevent that from happening. The first and foremost, and just to clarify, here in Nevada, it's not illegal to be registered in multiple, in this state and another. In fact, that happens, right? If somebody, I think as you cited, moves out of this state and into another state and registers to vote when they get there, there's a period of time where that individual is in fact registered both here and at the other state. That actually goes back to one part and one aspect of the ERIC process that identifies individuals who are registered in more than one state, notifies both states. We identify, again, who has the more current registration. Notifications are sent out, again, pursuant to state and federal laws. And so that an individual who is on another state's rosters would come off of ours or theirs fairly quickly. And then in regards to someone who's not a Nevada citizen who perishes in another state, who at one time was on our rolls, the maintenance process that would catch that is again, when any official elections mail goes out, and I will stress this again like I did yesterday and do hopefully every day between, well, I have the privilege of being in this position. If you receive official elections mail at your address, or you know somebody that does, for an individual who's not a resident there anymore, the correct thing to do is not to shred it, not to throw it in the trash, but to write return to sender on that official mail document, put it back into the mail, or hand deliver it to your county clerk or registrar. That starts a clock. Your clerk will then send a postcard notification to the individual to say, hey, we got official mail back from you. You didn't, it says that you're not there anymore. Please confirm if you are. Again, that's a requirement by federal law and state law for that matter. If that postcard, if the voter calls and says, no, it's me, here I am, yep, it was my somebody was in state confusion or I moved or whatever, then their registration gets updated. If it doesn't come back, then they're inactivated, which means that they're not going to receive a mail ballot. Again, if they are really just moved in the state, there's a number of, again, you see it gets pretty complex. If they just moved in the state or within the county, they're still eligible to vote once they update their registration. But there's a number of steps I think that will catch the situation that you described. But thank you for your comments, and that the whole process is something that, again, we continue to review and scrutinize. Ms. Benson, please.
Thank you. Sorry about that. Hello, Mr. Relashin, for the record, Alita Benson, Nevada Republican Party. You mentioned that there are processes to hold clerks accountable for updating voter rolls, and I wanted to touch on that, but I also wanted to say Ms. Lee brought up two salient points. First, if this regulation, if passed as written, it would not mandate the removal of any deceased voters until February 1st, 2023, well after the election. And I've heard you say, hey, yes, we send them out, but it wouldn't mandate it. And that's insufficient and odd that a date would be picked to ensure it doesn't take effect until after a midterm election. As stated by many of us, monthly maintenance and publishing of the deceased voters that were removed to the public is, I think, what most of us would see as a minimum, right? Because also, what if somebody's accidentally listed as deceased and then they have no way to rectify it? We'd also like to make sure they can have the information and have it be easily accessible. One point of concern, you stated that there are processes to ensure clerks maintain their roles. And this was touched on as, hey, we need something a little bit more muscly. We need an enforcement mechanism. And I want to occur that the situation occurred under your predecessor. So it's not, not at you, it was the predecessor, the former Deputy Secretary of State. But in Clark County, Joe Gloria in 2020 refused to remove over 81,000 voters from active to inactive status after the primary election when their ballots came back undeliverable. So Clark normally updates their public voter rolls every Monday. They took over 7 weeks to do the basic maintenance on these voters. And because so much time elapsed, they ran into the Voter Registration Act deadline against modifying voter rolls. So these 81,000 voters were sent ballots, 8,529 that were undeliverable in June, somehow voted by mail from the same address in October. This information was obtained via Freedom of Information Act request. It wasn't sent out to the public willingly. We had to use NRS to get that information. So having that enforcement procedure laid out to ensure that clerks are following the direction given by the SOS really helps voters have confidence in the voter roll maintenance process. And that's one of the reasons why we're so passionate about it. Thank you.
Thank you, Ms. Benson, for your comments. I appreciate that. We'll take it into consideration. Ms. White, yes, please.
Thank you. Just getting back briefly to the homeless registrations, where they're legally entitled to say, yes, I live at the corner of 4th and Center Street or whatever. So if a challenger, a legal challenger, someone who lives in that precinct can go to that corner and say, I visited this corner on Saturday, January 30th, or whatever the dates would be, and there was no person of that name at that corner. Is that sufficient evidence to disqualify that homeless registration?
Ms. White, thank you for the question. And specifically as it relates to that statute, you'll notice also that the 293-547 it's a clerk and a county clerk process. And while it's certainly enforceable by the Secretary of State, I think if that situation were to arise, I would recommend that you put it into a written challenge and submit it to the clerk so that the clerk and the DA can adjudicate it appropriately. Yes, ma'am.
Okay, thank you.
Ms. Williams, good morning.
Good morning. I want to touch on the homeless issue too, but I'm going to put into, well, I should say phrase it in another area. There was an incident where someone had just gotten out of prison. He didn't have any ID on him. He came in to register to vote, the same day voting system that we have that's really awful. He gave an address. When we put in that address, they did a search. It came up as couldn't be found. So therefore, he could not be registered to vote that particular day because we couldn't confirm that address. The person who was the lead, she made some phone calls, and because ended up that he could not register because we could not verify his address. But what crossed my mind was that if he did have an address that was verifiable, what was going to stop him from going to another voting site, using another address saying he doesn't have ID, and vote again?
Ms. Williams, thanks for your question. So the Help America Vote Act, in part, also requires the issuance of a provisional ballot for an individual who says, I'm not on the voter registration list, but I am an eligible voter. We're required, the clerks are required by law to provide that individual with a provisional ballot. So what does that mean? That does not mean that it's okay, you got us. Step up to the machine and off you go. What that means is that they get a ballot that they can fill out, and it gets set aside. It is not cast until the provisional ballots are addressed after Election Day. One of our processes that we have in place already excuse me, is to collect the names and information of all of the voters who have tried to vote via provisional ballot across the state, in part to do exactly what you're identifying. So that way, again, we check names, we review addresses, we make sure that nobody is trying to, cast a provisional ballot in Douglas, then Carson, then Story, then Lyon, then Washoe, right? So by this review process to make sure that nobody has cast multiple ballots, and again, right, like this is one of those processes that occurs. Did people try to do this in the 2020 election cycle? Yes, I know exactly who and how many people attempted to do this exact thing, but we catch it before those ballots are cast. Once we've confirmed the provisional ballots, again, are not duplicates in any county or other jurisdiction, the next step is to make sure, again, as part of this, concurrently, make sure they're an eligible voter. So that if someone says, I should be a registered voter here, I meet the requirements, they fill out their information, but again, the clerks confirm before that ballot is cast that they are in fact an eligible voter. So that there are some steps in place, but I appreciate your question though this morning. I feel like I may have strayed a little bit from the initial intent here of regulation, LCB file, proposed regulation, LCB file, or R104-21. Are there any other comments specific to this proposed regulation?
Yes.
Mr. Beatles, please.
Hey, just to touch on some of the things you just said there. Number one, with these multi-state voters, say for instance, somebody lives in California, but they're still registered to vote in Nevada. Are you able to track, do you track if they vote in both states? Number one, that's the first question.
Yes.
So what do you do if they vote in Nevada?
That's a violation of NRS 293-780. We collect information on it and we refer it to law enforcement. I'm not a fan of people violating our statutes.
Sure. Did you ever look into the GOP's published data on their website showing the thousands upon thousands that did that?
There's a great number of things that we looked into. I can't recall that data exactly, or if that was in fact part of the data that we reviewed. But there's a process that we have in place. So you're familiar with ERIC and what that does and what each state provides to that. You'll probably have noticed that California is not part of the ERIC process. So in order to ensure that we don't have a significant blind side with our good friends to the west and south, we've established and are working on a kind of an ad hoc ERIC process. The Office of the Secretary of State in both states, we talk, and we're working on solidifying a process where at the end of an election, their publicly available statewide voter registration list, rather in the vote history, is compared to the information that we have. Any possible indication of an individual with similar information in both states is reviewed and discussed. In discrepancies where that suggests an individual may have attempted or voted twice, once in each state, absolutely, it gets referred to law enforcement.
All right, and then the last question. If you go directly to the Nevada GOP site, they have proof of at least 42,284 Nevada voters that voted twice in the 2020 election. It's 42,284. So obviously the system that you're using isn't working, and there's little to zero follow-up on this, especially when it's published right there on their website.
Mr. Beatles, I actually reviewed that along with the 3,987 non-citizens, the 1,506 dead citizens, the 2,468 change of address out of state, the 15,164 non-Nevada mailing addresses, the 8,842 commercial registration addresses, the 8,111 non-existent addresses, 8,529 reactivated from non-active votes by mail, and the 6 voters within the name resident in Clark County. As I said, the Secretary takes all of this very seriously and has directed me very specifically to review and investigate every possible allegation. So again, a little bit off track from the regulation, but certainly open to discussing these issues with you at a future time if you'd like.
Yeah, I'd love to, because I mean, it's right there in our face and nothing was done about it. And we're contesting 182,000 addresses. So I'd love to sit down with you. And Eric is part of the problem.
Mr. Hindle, yes, please.
Thank you, Mr. Velasco. Just wanted to follow up, and if you'll give me a little latitude based on some of the conversation we've had here versus the specifics to this point. Just wondering, relative to homeless addresses and mail-in ballots, clearly a ballot cannot be delivered to the corner of Center Street and 4th Street in Reno. Are we relying on the U.S. Post Office to capture those ballots and return them to you? or maybe how are we managing that? Because clearly that's an undeliverable address.
Excuse me. Yes, sir. Again, you're right. And ballots are not forwardable. So when those ballots do end up in a location that is undeliverable, that is something that the post office does return, so that your clerks and registrars do receive a number of ballots back from addresses. And again, while maybe a little bit out of the scope of this regulation, this is something that we continue to take a very serious and close look at. And even incorporated the comments about GIS too. We've incorporated that into our requirements for the top-down registration system that we're transitioning to pursuant to Assembly Bill 422. So that there are opportunities in the future, as well as things that we're working on now to further improve this process to keep it accurate and clean. Ms. White, do you have another comment?
Yeah, I was for the homeless, you know, a lot of them use not even just street addresses, they'll use the address of a homeless services location, like the one on Record Street, 4th and Record. They used to let them use that mailing address to receive their mail. And I know firsthand that there is not secure delivery of mail to the people who are supposedly getting their mail there. So there's a problem there as well with individuals who may at one time have registered with that address, but no longer being there, and the insecure chain of custody or whatever after it gets delivered to that 4th and Record Street, it's no longer being used for there. But that mail, that ballot could just be distributed to anyone. I mean, it's not secure anymore. Thank you.
Yes, ma'am. Thank you for your comments. I will address 2 quick questions in the chat, and then we'll move on to the next proposed regulation. First, question from Mr. Kampf: have you ever had a conviction of this type of behavior? Again, while we gather the information, while we identify the discrepancies through a number of different systems and processes, again, and while we even have law enforcement officers as part of the Office of the Secretary of State, they conduct elections-related investigations in our Securities Division. As those men and women gather the information and review the facts of the case, they're the first step in addressing it from a law enforcement perspective. Again, it's into something that we probably need to talk about separately, about the entirety of that process from the time that we turn over information to law enforcement internal to the division, or sorry, internal to the agency, that they then, what they have to do in order to affect a conviction. To answer your question directly, again, this type of behavior, I think you mean elections fraud in general. There have been individuals over the last few years, and there are more that are under investigation for violations of elections fraud. And then a question from Ms. White: how is the SOS able to investigate the illegal votes counted? Again, without getting into too much of the detail, the bottom line is that we compare the data. There's a lot of data that we get about your voter registrations. Ballots are scanned so that your ballot envelopes, to be clear, are scanned. Ballots are not scanned. Envelopes are scanned. And in some cases, again, if there's multiple counties that have the same individual, we can see, sure enough, somebody wrote their name on the ballot envelope here and mailed it in one county, and then somebody wrote their name over here in another county. You look at the signatures, they use a little heart for the I and their name or other indications. And then again, that's the starting point for the criminal investigation.
No, but the point of the question was to say, in some place in this language, it says that the registrar of voters will confirm that, you know, some challenge or whatever. Is there a confirmation process other than the digital comparison of lists or vital statistics or whatever? I mean, is anything physically done? Thank you.
Yes, ma'am. Yeah, absolutely. Again, there's a requirement, a federal requirement, that all election-related information and documents be maintained for 22 months after an election. And so, yes, we do have documentation that we review, and there are physical things that are looked at beyond just names on rosters. Yes, ma'am.
But again, what I'm saying is a letter sent out saying, are you dead? Or does somebody from the elections, the registrar of voters office, go out and visit a location to see if they're dead, or not just lists and digital and paper documents? Is anything else done?
Oh, I see. I think anyway. So we are limited in what we can do. The paper notifications, again, one, if we receive information from vital statistics, that information is confirmed. They are not fast and loose with the death certificate, and they are very deliberate in their process to make sure that the information is accurate and that it's transmitted appropriately. There have been times when we've had death certificates that were updated and amended. I saw one that was 2 or 3 times and didn't come to us for about 4 or 5 months. Specifically because the individuals couldn't find the social security number, which is part of the critical information we need. There's a surprising number of folks out there that share our first names, in some cases even last names. And so again, to make sure that we're not canceling at the county level a voter who is still alive is very important. So yes, once we get a vital record a vital statistics record, the county clerks do act upon that, again, in a very timely manner, but they do not, visit addresses or those sorts of things. There are other ways too that individuals can be notified about deceased residents. If you have a family member there, there's a form that you can use to fill out. Frankly, you can just call or email, notify that your clerk or registrar about a deceased individual. They're going to ask for information. It's not just hey, my friend so-and-so died, can you remove them from the lists, right? Like there's a validation process, but certainly that is something that, again, that they take seriously to keep the lists clean. Mr. Williams.
Yeah, hi. Heather Carmen is the assistant registrar of Washoe County. She was kind enough to provide me with the following statistics. I'd just like to get it into the record. Of 5,173 provisional ballots for the 2020 election, 1,003 were rejected. 15,522 mail-in ballots came back to the registrar's office undeliverable or may have had no signature. So that just goes to the problem of homeless and ghost addresses and things like that. Thank you.
Thank you, sir. Ms. Thomas, please.
I just wanted to put on the record that I, polling place manager in 2018 at the Scalari's Shopping Center on Mariloma, we did have a gentleman and his wife come in, and he was on the voter rolls as deceased. We had to revive him. We had a Lazarus moment and had to revive him as a registered voter with his wife there and all of his identification proving that he was alive.
Yes, ma'am. And these are processes that we keep looking at to make sure that they are accurate. And when you're talking about large numbers, again, individuals like that, unfortunately, have happened in the past. But like I said, we continue to scrutinize it, look at regulations that we could address and other processes to try to improve upon them. But thank you for your comments. Yes, ma'am. Is there anybody else interested in proposing or providing a public comment regarding proposed regulation R104-21? If not at this time, then I will close public comment regarding proposed regulation R104-21 and open the workshop on proposed regulation R105-21. Okay, proposed regulation LCB file number R105-21. Existing law requires the Secretary of State to adopt regulations for the conduct of special elections in all cities and counties. This regulation provides that if a recall or special election is called in a county or city, it will not be held on the same day as the primary election, primary city election, general election, or general city election as applicable. 1, the appropriate clerk must notify the Secretary of State of the election. And 2, the Secretary of State will confer with the clerk regarding, if applicable, A, the use of the system of approved electronic transmission established pursuant to NRS 293D.200. B, the locations of polling places including without limitation, polling places for early voting by personal appearance and vote centers. C, the locations of ballot drop boxes for mail ballots. D, a plan for the security of ballots for early voting. E, a plan for allowing members of the general public to observe the conduct of voting at a polling place. And F, a plan for the accommodation of members of the general public to observe the delivery, counting, handling, and processing of ballots at a polling place receiving center or central counting place. At this time, I will open public comment. regarding proposed regulation, LCD file number R105-21. If you are interested in providing public comment, please go ahead and indicate so in the chat now. Mr. Beatles.
Hey, just a couple things on this one right here. So the voter registration via the internet has, a ton of security risks and disadvantages to those that don't have internet or they're otherwise technically challenged. So we ask that you delete that provision and that you maintain the mailed absentee and provisional ballots by request only, right? And those should only just be for like indefinitely confined and military. We shouldn't have this crazy, mail-in ballots to anybody and everybody. Also doesn't include a cost estimate. And as we saw in Wisconsin, drop boxes are illegal, right? So we need to delete that provision. As we saw in Georgia, they had 242 operatives in the cover of night stuffing these drop boxes for $45,000 a head. So as you can imagine, there are significant security risks with drop boxes. They are literally just designed to cheat. These things have no business being in our election system. All these things would just be so much easier if you just went to same-day voting in person. It solves everything. I'm clueless as to why we don't make it election day instead of election month, why we do mail-ins. Why don't we just vote in person on one day and have a legitimate election?
Thank you, Mr. Beatles. Again, just for clarity's sake, drop boxes are illegal in Wisconsin pursuant to Wisconsin law, I believe. Drop boxes actually required pursuant to Nevada revised statutes.
That's why we're number 50 in election fraud.
I appreciate your comments. We'll take them into consideration. Ms. Lee, please.
Oh, sorry about that. The regulation doesn't have a time limit. So if the county needs to do a special election, there's nothing like 45 days, 30 days of notice to the Secretary of State. So the Secretary of State can't, you really need to have some kind of timeline, time requirement so that the Secretary of State's office and the county clerk are prepared for this special election. Thank you.
Thank you for your comments, Ms. Lee. Mr. Kampf, please.
Yes, thank you very much for the opportunity. This regulation requires for a plan for the accommodation of members of the general public who observe the delivery, counting, and handling of and processing of ballots at a polling place, receiving center, or central counting place. Does that receiving center include the central post office? Because I know that the mail for Nye County is initially processed in Clark County and then sent here. So does this allow for the observation of the chain of custody of those mail-in ballots who are first received, where the first chain of custody point on a mail-in ballot is with the U.S. Postal Service? Does this provide for any provision for observation of the handling of ballots by the U.S. Postal Service?
Mr. Kampf, thank you for your question. Again, specific to, pull it back up, proposed regulation R105-21, again, it identifies those locations. It does not say in there, I believe, anything about the post office or counting or tracking. So I'll put that down as a comment that maybe a recommendation that you are making in regards to adding in visibility of chain of custody starting really at U.S. post office locations as well. Is that accurate?
Yes, that's accurate. And also, is there any plan for the video recording of ballot drop boxes? Because again, that is initial point of chain of custody over ballots, and that any tampering with the ballot boxes should be evident, or for poll watchers to be able to constantly observe these ballot drop boxes.
Yes, sir. Thank you for the question in that regard too. I'll also add that as a recommended modification to the regulation. Again, the idea of observation of ballot drop boxes is something clerks have discussed again with myself and the secretary pretty extensively. Most of the clerks right now, in fact, have ballot drop boxes set up in their polling locations specifically, or other locations for that matter, specifically so that they can be manned and observed at all times. I think to address exactly what you're saying. Part of it, though, the video portion, I think, gets at something a little bit different, not necessarily the security, but maybe even, again, going to transparency by the public of what's occurring at ballot drop boxes. That's also something that has been discussed at length, again, with other states that have tried that or that are currently doing it. So we're still reviewing some best practices and trying to understand what would best fit, the Nevada electorate, recognizing that, again, certain parts of the state where a ballot drop box might be placed, there may not be, for example, Wi-Fi or other internet connectivity that would support a live stream video. But I will take your comments down and make sure that we consider them going forward.
Thank you very much.
Sir. Ms. White, please.
Thank you. Chain of custody is everything. You have individuals going to drop box locations and they're removing the ballots from the drop box. Wow. Can observers tag along with these people who are going to the drop boxes to pick up the ballots? Because it seems like the transparency is not there if just two individuals who are picking it up are unseen, basically unmonitored. Thank you.
Yes, ma'am. Again, for clarity's sake, again, the ones that are at polling locations, again, will be available for observation. Other locations, again, have bipartisan collection teams. Again, a very deliberate part of that process too, to ensure increased security. And then lastly, that there's nothing, I believe, preventing observers from watching poll box or drop boxes themselves either. So that if you're interested in monitoring certain drop boxes, again, there's nothing preventing someone from observing them.
Yeah, but if once they're in transport, I mean, it would be necessary to be notified of when they're going to go out to pick them up, and I mean, to follow them. If we want to be observing the entire process, we need to watch them pick it up, unload it, put it in their vehicle, drive to the registrar of voters, deliver them. I mean, full transparency would mean we'd be able to monitor that entire process, not just watch at the box and then watch them leave.
Yes, ma'am. For what it's worth, that happened in 2020. I know for a fact that did. And
okay, so how are we supposed to know when these teams are going out to pick up contents?
It varies depending on the county, the resources they have available, the number of poll workers they have to support that effort. As again, you can imagine, now that we have a requirement for mail drop boxes across the state, and an increased requirement that requires an increased number of poll workers of a bipartisan nature, so that we can have more people going out to do these trips. We've got locations across the state where, in some cases, I know of one in particular I'm thinking of, it's 130 plus miles from the county seat, one way. So that those sorts of trips, again, are something that the clerks consider and develop transportation plans internal, but it will vary county to county. Best recommended action in this case then is to talk to the county clerk or registrar and ask about that. If they have a process or a timeline that they can provide, they will. But there's a number of different ways that it's being addressed.
Okay, so what I'm hoping for is to find the registrar should be able to post publicly when these drop boxes are going to be picked up, so that we, volunteers who wanted to observe for full transparency, could arrange to be there and to follow them back. And secondly, are the teams working that are picking up these drop boxes, are they using government vehicles or private vehicles? And is there always two people bipartisan picking it up? Thank you.
Yes, ma'am. Thank you for your comments. I'll definitely take that in consideration and make sure we capture it here now. And to answer directly, I don't know specifically in every county how many people and what the deal is. But again, the bipartisan teams to collect, again, it's different in each county, as we talked about a little bit yesterday too. But yes, ma'am, we'll write that down and definitely consider it.
And government vehicles are used or private vehicles?
I would have to confirm that as well, ma'am. I believe it's government, but I'll confirm.
Okay, and how do I learn what you confirm?
I can get in touch with you.
That would be great.
Yes, ma'am. I believe you submitted a written testament as well?
I did.
Perfect. Excellent. I have your email address then, and I'll be able to get in touch with you.
Okay, thank you.
You're welcome. Ms. Lee, do you have another comment?
No, I'm sorry, I forgot to lower the hand. Thank you.
Mr. Parks, please.
I'm absolutely shocked and amazed that the Secretary of State's office can't see the problem with these drop boxes scattered throughout the state. While I'm more than cognizant of the distances that some people have to travel in order to cast a ballot, the entire concept of drop boxes is just rife with problems and should be eliminated. Thank you.
Thank you, sir. Ms. Martinez, please.
Yes, good morning. Thank you. My name is Cindy Martinez, for the record. I am the vice chair of the Washoe County Republican Party. And to piggyback on the concerns about ballot boxes, I was a poll watcher at I think it was 3, maybe 4 locations during the election, during early voting as well as voting day. And the first thing I checked for when I looked at the ballot boxes at each of those locations is that none of those boxes were serialized. So there was no accountability here in Washoe County for the county to say, we sent out 20 boxes, and so we can account for the collection and also the return of those boxes to the county. So that's a problem right there. The other points that I would bring up regarding the runners that were picking up those ballots, some of those were married couples who were partnered on the being running teams picking up those ballots. So that's problematic. You could reasonably assume that you would hope that they would have integrity, but I still think that there should be some checks and balances. And of course, that is a Washoe a county point to correct. Sparks Justice Court was one of the locations for a ballot box. And we initially, if I recall correctly, were going to set up a watch at that point, but we were so limited on folks that we had to put throughout the county. I'm not sure that that was watched. Now, I don't see how you can provide adequate oversight to a drop box located at Sparks Justice Court when you've got the armed security that's responsible for ensuring courtroom security, and there was nobody assigned to watch those. There's inconsistent means of marking the receipts and tabulating the contents inside the ballot boxes in reconciling it to those that were scanned. In particular, one of the days I watched at Sparks Library, there was a discrepancy between scanned ballots and physical ballots that were counted, and they were counted out in public. And one of the ladies that was working as a poll worker said, well, it just matters how many ballots you count. So if that's just one tiny little snapshot of what's happening in our county during early ballot voting, one can reasonably assume, based on what I saw in the different locations I worked at, is that there are no checks and balances. Oh, and to Ms. White's question too about private or county vehicles, the people I saw collecting ballots were driving private vehicles, not county vehicles. But there are no checks and balances. There's vulnerability at every level in the county regarding early voting, accountability, reconciling of votes, in addition to the problem with ballots going out to Record Street and general delivery. Thank you.
Yes, ma'am. Thank you for your comments. I do appreciate it, and we'll certainly take it into consideration. This is a new process, not making excuses. In fact, I'm simply highlighting the fact that there's importance and utility in the public comment. So again, all of you that have joined today, again, want to take a moment to thank you and appreciate your input into this process. Again, pursuant to Zoning Bill 321, it was enacted effective January 1st of 2022. 19 days ago. We've been thinking about this since the legislative session and continue to work with the clerks on improving it. But very similar to even your concerns highlighted about the absent ballot process that we've had, I believe, since 1921. There's a growing a learning curve, something that we're eager to get ahead of and continue to address. But the goal is to continue to improve these processes and to make sure they're as secure as possible. So thank you for your comments, Ms. Martinez. Question, Ms. White, about identification process established for the runners picking up ballots. I think you mean the poll workers, validating that they're poll workers that are picking up the ballots?
Okay, so two people show up at a ballot box and they say, yeah, we're here to pick up the ballot box.
Oh, right.
Okay.
Yeah, there's, so again, county specific, at least a little bit of regard, but you're absolutely right. Like there is a requirement for only certain individuals who are allowed to pick up ballot drop boxes or to pick up the mail ballots from those drop boxes. But I will take that down as a comment and a recommended clarification.
And probably picture ID as well. Do poll workers, election workers have photo IDs to identify themselves?
As in regards to their personally issued IDs or something that's issued to them temporarily for the conduct of the election?
Temporarily by the elections division.
I would have to check again. I believe they may vary county to county. Part of the concern there, I believe, is that some folks are poll workers for a day, some work for 2 days, some are able to work for the entirety of the early voting period. Some work for the entirety of the early voting period through election day, and then even the post-election period, right? Because of the continued work that we have on mail ballots, 4 days now after the election, 2 more days after that for the curing of signatures. But I'll clarify that as well.
That would just seem to be an area open to a lot of fraud as well. With somebody saying, yes, I'm a poll worker, I'm this, that. And if you gave them photo IDs, would they be valid for 1 day? I mean, there's, again, universal mail-in ballots and the whole process of counting and picking them up is just asking for fraud.
Okay. Thank you for your comments, Ms. White. Ms. Martinez, do you have another comment? Ms. Thomas, do you have a comment?
Yes, I wanted just to verify that Washoe County, all poll workers, whether they're 1 day or 2 day, are hired. They have to go fill out an application with Washoe County. They are a county employee, and yes, they are issued a badge with their picture on it. And they are collected at the end of the election cycle. So every election, we get a new picture and a new badge for that election.
Excellent. Thank you for the input. I appreciate that. At this time, is there any other public comment regarding proposed regulation R105-21? Seeing none, I will close the public comment on proposed regulation R105-21 and open the workshop on proposed regulation R106-21. Proposed regulation LCB file number R106-21. Existing law requires that at least once a year, each county and city clerk and all staff members and such clerks whose duties include administering an election complete a training class on forensic signature verification that is approved by the Secretary of State. Section 2 of this regulation provides that 1, the Secretary of State will publish biennially a list of approved training classes, and 2, to be approved, a training class must include a written test on forensic signature verification. Section 3 of this regulation provides that with certain exceptions, each county clerk, city clerk, and all members of the clerks whose duties include administering an election must annually complete 1, a training class on forensic signature verification, or 2, a refresher class on forensic signature verification. Section 3 also requires each county or city clerk to annually, 1, identify which members of his or her staff are required to take the classes, and 2, submit to the Secretary of State certificates of completion of the classes. Section 4 of this regulation provides that if a county or city clerk determines that any member of his or her staff whose duties at a particular election include checking the signature of a voter at a polling place or on a mail ballot has insufficient time to complete an approved training class on forensic signature verification, the clerk may authorize another member of his or her staff who has successfully completed such a class to provide to the person at least 2 hours of hands-on training related to checking the signature of a voter. Section 5 of this regulation prohibits a staff member of a county or city clerk from checking the signature of a voter at a polling place or on a mail ballot unless the person has successfully completed an approved training class on forensic signature verification or received the training described in Section 4. At this time, I'll open public comment regarding proposed regulation R106-21. If anybody's interested in providing public comment on this proposed regulation, please indicate so now. Ms. Martinez, do you have a comment? Oh, Mr. Beatles.
Yes. So again, you know, a lot of this stuff is just highly unnecessary. If we just get rid of the signature verification and we just do, you know, picture ID, a government issued picture ID with their signature, that solves this entire problem. We have tons of reports. We have witnesses in Nevada, in Clark County, where they actually dialed down the signature verification machines. I believe it's called a Gillis or something like that. They dialed them down to where basically you could sign it with Santa Claus and it was going to be accepted. All this stuff goes away if you just do, you know, voter ID, in-person voting, same day. All I got.
Thank you, Mr. Beatles. Mr. Williams, please.
Yeah, kind of what Mr. Beatles was saying. In my understanding that this reg change would nullify the need for DMV signature verifications, because that's a good thing. We save a lot of money and it's a lot safer. I trust individualized and human intervention than the machines, particularly with cities. You know, like I go to the supermarket and you sign your name, it never looks like my signature. And oftentimes one signature to the next, I could have a bad day and just scribble, make a mistake. Signatures may change over time. You never know, some people do change their signatures. So those are inconsistencies in the whole signature, electronic signature verification system. And so thank you, that's pretty much my feeling on it. Thank you.
Thank you, Ms. Williams, I appreciate your comments. Ms. Lee, please.
First of all, I want to thank the Secretary of State's office for actually adding this in, because this is pretty important. We actually are having training for the first time, forensic training for the election workers. So I appreciate that. However, there are a couple of things that I am concerned about. What constitutes a passing grade? Is that a C+ or F or D or B-? That needs to be clarified. Also, when you talk about 2 hours, at least 2 hours of handwriting in Section 4, does it make more sense to actually, instead of having 2 hours of hands-on training, more of that they have reviewed and trained on like 100 samples of signatures? It makes more sense because you don't do, at least for physicians, you're looking at how many cases have you done? How many heart surgeries have you done? As opposed to how many hours of heart surgeries do you do? So it makes more sense to say 100 samples or something similar in terms of training. Third, according to Section 3, the submission to the Secretary of State is honored before April 1st of each year. I maintain that they should actually report to the Secretary of State twice a year, once, which is April before the primary, and then another probably in August of that year, because for the general there may be additional people who have been trained. So those are my suggestions. Thank you.
Yes, ma'am. And actually, I appreciate your comments. You actually brought to mind that there's some written feedback that we've received that we're already planning on possibly, considering for a modification to this proposed regulation, is to do something very similar. One, to make it, so you're right, the date of a once, in April deadline for submission of the list of names doesn't capture the fact that there are people that are hired as poll workers, in some cases up to and including after the start of early voting. So how do those individuals, how do we capture to make sure that those individuals also have to receive this training? And then also, the comment about if someone isn't able to take the test, what we're looking at doing is setting it up so that there's really no reason why somebody wouldn't be able to take the training and take the test. And that the idea of, relying on almost a telephone game of I'm trained, now I try to explain it to you, allows for some level of deviation that frankly I would rather get away from, and having standardized tests, standardized classes that are approved ends up providing for a more consistent amount of signature verification across the state. But thank you for your comments. Definitely take those into consideration. Mr. DeGraffenreid, please.
Good morning, Mark. For the record, Jim DeGraffenreid. I am Nevada's Republican National Committeeman. Thank you again for facilitating this public comment process. As I mentioned yesterday, we are stuck with the laws that were passed in the legislature, and we feel like this process is our last defense to get integrity. We support transparent, fair, and legal election training, and we thank your office for including this regulation. After the results observed in 2020, where shapes and symbols were accepted as valid signatures in Clark County, transparency around signature verification is sorely needed. This proposed regulation does need some clarification in order to truly drive consistency of signature verification so that every voter has the same standard applied to their ballot, whether they live in Battle Mountain or Boulder City. Currently, this proposed regulation allows for unapproved classes that have not been reviewed by the Secretary of State to be taught, and that will not work. Any and all training materials for signature verification must be approved by the Secretary of State and be available for public review. Additionally, as we saw with the recent grading changes in the Clark County School District, passing doesn't always mean competence. It is essential that there's a clearly defined grading standard. For example, the passing score of 85% and above be the only ones accepted. Finally, Section 4 allows employees who have never received training in a Secretary of State certified class to train another employee. And that creates a situation where a worker reviewing ballots potentially never received any approved training. That's ripe for abuse, and Section 4 should be omitted entirely. Thank you for your consideration.
Thank you, Mr. DeGraffenreid. Appreciate your comments. We'll take them into consideration. Mr. Sackerson, please.
Good morning again. Thank you for the opportunity. In terms of Regulation 106-21, Section 2, passing grades for signature verification are pretty close to the heart of election integrity. A passing grade of 80% should be incorporated for these classes for those who will be administering elections. In terms of Section 3, the original provision states a refresher class is not required to be approved by the Secretary of State. All training must be approved by the Secretary of State, and all must have that 80% passing grade that I noted for Section 2, subsection 2, or a similarly high level of passing. And then finally, Section 4, in lieu of this provision, just simply strike it. I recognize that we probably can't make this change here, but boy, fingerprints would make it sweet and simple. And those are very common in a lot of employment settings. And quite frankly, they're very common throughout the world. Thank you much.
Thank you for your comments, sir. I do appreciate it. We'll take it into consideration. Mr. Watson, please.
Thank you. For the record, once again, Alex Watson, RNC's Election Integrity Director. We do have several concerns with R106-21P, the first being Section 3, subsection 2. The RNC supports election training wherein participants are required to undertake an examination and obtain a passing grade. However, there must be oversight on that process to ensure quality and that the information being offered is accurate. The only way to ensure any course offered is accurate and training is sufficient is for all such courses to be approved by the Secretary of State. So we propose in this subsection be changed to reflect the following, quote, except as otherwise provided in this subsection, any staff member whose regular duties at the office of the county or city clerk include signature verification and who, for 2 consecutive years, has taken an approved training class on forensic signature verification and received a passing grade on the written test may, in lieu of a training class described in subsection 1, attend a refresher class approved by the Secretary of State on forensic signature verification and receive a passing grade on a written test administered following the completion of a refresher class. Additionally, Section 4, our concern is that the completion of a training class does not necessarily qualify someone to train others. Employee-to-employee training is not effective and potentially ripe for abuse. To add on to Mr. DeGraff and Reed, we also propose that this subsection be omitted or modified to require temporary staff to complete formal training as well, approved by the Secretary of State. Thank you.
Thank you, sir, for your comments. Mr. Parks, please.
Again, for the record, Bruce Parks, Chairman of the Washington County Republican Party. I could not agree with Mr. Watson and Mr. DeGraff Reed. Section 4, I couldn't agree with them anymore. Section 4 needs to be eliminated in its entirety. There needs to be a clear standard established for the training and testing of the personnel that are going to be verifying signatures. Verification should not be done by machine. It should be done only by persons. Thank you.
Thank you for your comments, sir. Ms. Martinez, please.
Yes, good morning. Thank you again, Cindy Martinez, for the record, Vice Chair of the Washoe County Republican Party. Regarding this signature verification, I agree with Mr. Beatles and Oscar that the necessity of this goes away if the insanity of this process, the entirety of mail-in ballots goes away. Having said that, the process of training somebody for 2 hours to make them competent and, quote, an expert in evaluating handwriting is problematic. If you consider the high standard of training and certifications required in criminal cases when verifying handwriting exemplars to be submitted as evidence, I would submit to you that a 2-hour training conducted to civilians who do not understand, I don't want to be disrespectful, but may not completely comprehend the subtleties of verifying signatures leaves this open to great subjective interpretation. And if you are going to enable peer-to-peer training, that further erodes the integrity of the verification process. So, and I would question is this training proposed? Is it going to be an online training? And we know that you can turn off your video and your speaker and just have it running while you're doing the dishes and say that you've attended the training. So if this is going to be the means by which verification is accomplished, then it needs to be a very stringent process. There needs to be a means of accurate and consistent assessment of competency in evaluating and verifying signatures. Otherwise, it's just another avenue of weakening our vote. Thank you.
Yes, ma'am. Thank you for your comments. Just for clarity's sake, this process has not been formally defined yet. This is something that's still under extensive review. But ultimately, right, there's a statutory expectation that a poll worker who received, and you're right, maybe it's an hour, maybe it's 2 hours of training, maybe it's 2 hours of on-the-job training or experience, even over multiple election cycles. That individual is not the one ultimately responsible for the verification of that signature. That is a clerk and registrar responsibility, period, as defined in statute. 293-325 specifically lays that out. So this process, again, there's multiple steps to it, right? Because certainly in Clark County with 1.3 million, or for that matter, in Douglas, with its approximately 40,000. The idea behind this step is so that when a bipartisan team reviews the signatures on those mail ballots as part of that initial step against the voter registration database, if there's a question at all, then there's really no question, right? If the signature on this ballot doesn't match what we have with the voter at all, then that individual, the poll worker, that's their role to say, there's a problem here. You agree there's a problem here? Got it. And then brings it to the clerk to make sure that it goes to the next step in the process. Clerks typically at that point will confirm, yep, it doesn't make sense, send it to the signature curing process. But you're right, that this is a critical step in the process. We're all well aware that when it comes to mail ballots, that the signature verification is the last gate, so to speak, before that ballot is separated from the envelope. And at that point, again, there's no getting it back, right? Because of the secrecy of the ballot. We don't know once it's separated which ballot goes to which envelope. So this is something the Secretary takes extremely seriously. The clerks take extremely seriously. And while it's a relatively new process, There's a number of assets, different characteristics of it that we're examining to make sure that the process is done appropriately and that the training that we provide, or that is required rather, is effective. But thank you for your comments. Yes, ma'am.
If I may, please. To your point about that, I would say then training and certifications then need to be strengthened at the final point of analysis and approval, because you still have human subjective review, analysis, and adjudication. And if you talk about somebody like an elderly person, I myself am 60 and I've seen my own signature change over the years. So there needs to be a way to really tighten that up. And I understand what you're saying about establishing the regulations at the first point of review and adjudication. But if we're still going to assign that to fallible human beings, those fallible human beings must have a tighter means of certification and accountability. Thank you.
Yes, ma'am. And I appreciate your comments. One last thing, another aspect of this process that we're examining, right? And I think you touched on it a little bit, though I'd suggest that you're a little bit younger than the age group that I'm thinking of. But there are a number of voters whose signatures have changed over the decades. I remember my grandmother's signature was perfect and exact the entirety of her life until about her last decade or so. In that regard, there are kids that are being raised without knowing how to do cursive and don't have consistent signatures. My kids included. We taught them signatures and cursive specifically to make sure that they learned how to do it, because it's not something that necessarily they learned in any of the Department of Defense schools they were part of while I was in the military for the couple decades I was in, nor in some of the other schools they've attended here in Nevada. So that on the one end, there's the concern about an aging voter. On the other hand, as I just identified, there's the concern about the younger crowd of voters that are coming into voting age that maybe never had a consistent signature, and making sure that we try to address and get ahead of that, so that as the younger voters increase in number, that we're putting into place training that supports signature verification, regardless of whether it's a perfectly amazing, very beautiful script, like I mentioned my grandmother had, or like my children's kind of blocky handwriting that thankfully I've got about 5 more years before that ends up on the voter rolls as well, when they reach voting age. But yes, ma'am, complex problem, certainly an important security thing to consider, and something that we are aggressively looking at to make sure that we get it right as quickly as possible. Thank you. Ms. White, please.
Thank you. A couple things yesterday, and it's still related to this item. We talked about software that would, on the screen of the signature verifiers, just isolate the signature so that observers could actually see it, because you said observers couldn't get too close because there's private information on there. So what needs to happen? What do we need to do to request that, or you just put it in there that the screens that are verifying signatures need to isolate the private information? And then number 2, the training program that these people attend for signature expertise, is it made public who's doing the training program? And is that a certified program? 3, can the public at their own expense say, I want to be a volunteer to watch? Can I attend that same training program along with the government employees who are being trained? And 4, regarding signatures changing over the years, that would just indicate a need for flushing the entire voter registration list every 5 years or so to let people re-register and update their signatures, so we wouldn't eliminate thousands of signature questions. Thank you.
Yes, ma'am. Thank you for your comments. We'll take them into consideration. Mr. Kemp, please.
Yes, Mark Kampf, and for the record, candidate for Nye County Clerk. Thank you for the opportunity to comment. For those of you that worked in the corporate world or in the government where you're subjected to annual equal employment opportunity training will know that that training requires you to actually have 100% grade by the time you're done. You're not allowed to move on from that training until you've been able to answer all the questions or respond to the scenarios with the correct answer. My concern is that any grading process that is anything other than 100% is not going to be sufficient for those that are going to be assigned to reviewing the signatures and ensure that they're appropriate. My concern would be that anything that would say, well, if you're 80% right, that's okay. Well, that means that you're 20% wrong. And I don't think 20% wrong is a sufficient grade for someone who's going to be determining whether or not the key, the absolute key control we have over the validity of a ballot is in place. So I'd appreciate that you'd consider having that sort of training, and whoever you select to use the same sort of process that's used for equal employment opportunity training in the government and large corporations. Thank you.
Thank you, Mr. Kampf. Ms. White, just to clarify, your questions, I'm taking them more as recommended changes to the regulation. Again, the process has not been formally decided. There hasn't been an identified program yet. So I put I recorded that you would recommend that we modify the screens that allow for signature verification to be made in a way, or modified rather, so that the signature is isolated from the rest of the privately identifiable information, that you recommend that we make the training publicly available as well so the public can see it, to ensure that it's certified by the Secretary of State, and that the public can attend the training, as well as, again, as signatures change every few years. You recommend that maybe we flush the voter rolls every 5 years or so. Again, as I didn't see those so much as questions as recommendations. Is that accurate?
Well, are you just going to recommend, I mean, is there any way that this could get into the regulations that county registrars should do that? Or are you just taking notes of what my comments were? I mean, is it just dying right there on your desk, or is it really going to go anywhere?
So all public comment we received today verbally, as well as the written comments that have been submitted before and up through the adoption processes, again, will be considered. You may have noticed already that there at times are individuals that make recommendations about a regulation to either strengthen or weaken certain regulations, in some cases to add to or remove entirely. So what we do is, upon completion of these hearings, of these workshops rather, we're going to review all of the comments, both written and that was provided orally, critically consider it. It's certainly under no obligation to adopt all of it, and I don't think it'd be possible to. Again, we'll review ideas that are in accordance with and do not conflict with statutes, right? Of course, because Title 24 is the ultimate guiding book of statutes that dictate what the regulations are supposed to be. So I certainly can't adopt a regulation or a modification to this regulation that conflicts with statutes. And certainly, again, there have been a lot of really good ideas presented today and in writing. So no guarantee that we'll adopt every suggestion, but certainly take into consideration, as is what the process is intended for. This is the point where we've provided drafts and we want public ideas and input and comments to make them better as we get closer to bringing them to the Legislative Commission for approval.
Thank you. So will there be an additional workshop or meeting such as this where we will be able to see what of our suggestions or requests were included?
Yes, ma'am. In fact, for today, the regulations we discussed today on February 2nd of this year. So 2 weeks from yesterday, we will have an answer on that because those will be ultimately the proposed regulations. There may be some ideas too that we think, again, are worthy of either a unique regulation of their own or even possibly a suggestion to the secretary. She may say, you know what, I want to make a bill draft request, a BDR, based on that suggestion going forward. So again, if an idea that you've presented doesn't fit quite in with the regulation, that there are still a number of opportunities for it to get worked into the formal processes. And along those lines too, don't put all your eggs in one basket. Again, I encourage you to talk to your representatives, your assemblymen or women and senators. Let them know what your ideas are as well. Because again, if Secretary Sagaski terms out, of course, this year, and the incoming Secretary of State may, again, wholeheartedly agree or may have separate regulations or ideas for BDRs that they are interested in pursuing during the 2023 legislative session. A lot of different factors is the bottom line in different ways that these processes occur. Again, all defined by statute, all publicly available and transparent. But I don't want you to be disappointed if not every suggestion made today orally or in writing is accepted into the regulations, if that makes sense.
Okay, thank you. So in order to learn when and where and how to access the February 2nd meeting, can you provide the link for that? And secondly, is there a mailing list that I can get on to be automatically notified of when these kind of hearings or workshops are being held, other than me going to your website and checking every day?
Yes, ma'am, absolutely. And I appreciate you asking about that. So first and foremost, I will copy and paste into the chat both the notices for the hearings on February 2nd and 3rd. The regulations we're talking about tomorrow, we'll have a similar meeting 2 weeks later. And then I'm also going to put into the chat the link to our e-notifier system. Our e-notifier system, you sign up, you can identify what sort of notices that you're interested in receiving. And when you do so, then as a public workshop, for example, comes up, you'll automatically be notified through email about that and with all the pertinent information as well. So give me one moment, please, and I will copy that over.
Thank you for that. That'll be really helpful.
Yes, ma'am. It'll take just one moment, please, but I'm going to pull that information up and give it to you right now. First, as promised, there's the link to the e-notifier. Again, you'll notice that the information that you're interested in gathering, everything from press releases, information about the Elections Integrity Task Force. There's a number of commercial recordings, business-related notices that you can get as well. Put that one there.
And how soon will the recording of these meetings be available, or are they already?
Within about, I'd say about 15 minutes from the time we're done. If you reach out to the public information officer via the email that I provided in the chat earlier, she will be able to provide that information to you.
That's wonderful. Thank you.
Yes, ma'am. And just to make sure that you're aware of it and know to ask for it, again, there's the chat, just so that nobody is worried about trying to capture that or think it's going to get lost. When you request the information or the video link, the chat will also be in there as well in its entirety for your available review.
And what will the title be of this February 2nd meeting?
Just put it into the chat. That's the notice, is the notice of intent to act upon a regulation. The way the process again works, as defined by the statutes of the Administrative Rulemaking Guide, we have public works. We draft something, public workshops to gather and solicit input. We consider that information. The adoption hearing is us saying, the Secretary is saying, this is where we're at. And then from that point forward, the next important step will be the legislative commission that we talked about earlier. That also is something that, again, if you're in, we don't provide the notifications for the legislative commission, but on the legislative website that I sent the link for, also in the chat, they'll be able to review that. I'm sorry, they'll post the notice for that, and that way you'll get the contact information to either attend in person or virtually, depending on how the legislature ends up setting that commission up. But that right there that I just placed is the link to the notice for February 2nd. And then here is the one for February 3rd. Ms. Benson, make sure you're still on here. Yes, you are. Yesterday, you asked about the notice in regards to the additional workshops from yesterday. So as I mentioned before yesterday, and just for everyone's awareness, there was an administrative error on the agenda for yesterday. So we scheduled a separate, an additional workshop on the items discussed yesterday to provide an additional opportunity for public comment. That date was identified, and I have that notice as well as the rescheduled adoption hearing for the regulations discussed yesterday as well. I'll put both of those into the chat right now while I'm thinking about it as well, so that way everybody has it.
Thank you so much.
Yes, ma'am. Yes, Ms. Brock, the hearing on February 1st has been canceled. We're now going to have one on February 2nd, 3rd, and then 4th with the agenda and timeline that I just posted in the chat. And that adoption hearing that was going on the 1st has now been rescheduled until later in the month, on the 22nd day of February, using that notice there. Okay, I think that answers the questions right now. Is just to get back to the proposed regulation, is there any further comments? I believe we're on proposed regulation 106, proposed regulation with the LCB file number R106-21. Mr. Kampf?
Sorry, I should have put my hand down. I'm sorry.
Ms. Thomas, do you have any comments? Okay, perfect. Mr. Parks, do you have any additional public comment?
Just a quick question.
Yes, sir.
If you could please clarify, if possible, the justification for the all mail-in ballots. Why are we doing?
I'm not done. I'm not done. I wasn't done. Sorry. I thought I had 2 minutes.
Oh, I'm sorry. I didn't hear you. Miss Thomas, you hadn't been talking. I apologize.
Yeah, I think I got muted somehow. But anyway, I just wanted to point out that all of the training on signature verification is not going to do any good if the intake people are not even looking at the signature to begin with. When we get slammed at these polling locations, that's the first thing that those intake folks are doing. They're just trying to hurry up and process voters, and they start to neglect looking at those signatures, so that it is very imperative that we have both intake people verifying that signature, just not one person at a time. And the program is written as such. Once you've selected your voter and then they've signed their signature, that the screen comes up with just the signatures on it. So there is a moment in time where you can capture just the signature without the voter's information. And then once the intake person says they are going to accept that voter in order to activate that card, that is the moment that you could briefly flash it up onto another TV monitor for observers to quickly see that, yes, the signatures match. However, you really don't want to be leaving those signatures hanging up there, because then people with ill intentions could start scanning those signatures for whatever use they want later on down the road. So that's something else that's got to be taken. I don't know if everybody remembers way back when we had the paper, they used to cover up your old signature when you were writing your signature, so you weren't merely just copying what was there on the paper. So there is some reason for keeping that signature from the voter until they've given their updated signature, so we can match it. It's not something that you want up before the signature, before the voter's actually signing. So there's a delicate balance of actually when you want that to happen. But it is imperative that we make sure that these intake staff do not get overwhelmed and pressured by peer pressure just because there's a line going clear around the store to hurry up and just process that voter without checking that signature. There's got to be some type of check and balance to make sure they're actually checking the signature, because that's the other thing on the back end in the administrative side. When those signature books are coming into the registrar of voters office, those signatures aren't getting checked on those papers. I checked papers this last election, and 1 out of every 10 signatures did not match, and nobody was doing anything about it.
Thank you for your comments, Ms. Thomas. Mr. Park stepped away. We'll give him a moment to return, because he did indicate he had some public comment he wanted to make also. I think it's probably worthwhile to, again, remind everybody, we have differences across the state in how the counties conduct elections at the county level, right? Everything from the fact that Carson City and Lander have different elections machines, their systems are different, from the other 15 counties. The fact is that there are election management systems that are slightly different. There are processes and procedures based on resource allocations at the different county level too. So again, there are things that are possible and within, again, that fall absolutely within the confines of the statutes and regulations, but that will be conducted in slightly different manners in different locations depending on where you're at. So again, the intent as much as possible is to solidify, but for example, the dropping off process, right? In Clark County, again, there's a number of over 120 drop boxes. It's not possible to verify signatures at the moment of delivery for all those individuals, as it may be in a smaller county with a different resource pool. But these are all things, again, that the clerks are very cognizant of, these changes, and are working hard to make sure that the processes that they identify and the way they train their poll workers and the things that they set up and in place, the number of people they recruit, all these things are factors they have to consider and weigh. Mr. Parks, are you available by any chance? Give him a minute. Is there any other public comment relating to proposed regulation R106-21? Ms. Williams, please.
I have a question on the ballots that are either mailed in or dropped in the box. What happens when the signature does not match? How is that corrected? Thank you.
Yes, ma'am. Excellent question. So if there's any question about signatures not matching ballots, then the ballot is identified for the next step in the process, that is to go to the signature curing process. Again, relatively new process that we have here in the state, but not one that thankfully is that we're not breaking ground on necessarily. The signature curing process involves the clerks reaching out to the voter in a number of different ways to notify them really that they need to contact the clerk. This is something, again, that we're attempting to be as outspoken as possible, and certainly encourage you all to be mindful of. There were folks that had contact with their clerks, and the clerks reached out by, in some cases, text, email, phone, letter, postcard notifications. Please, we need to talk to you, and that were ignored in part because maybe folks didn't answer the phone or didn't see the letters, those sorts of things. But when you deliver, when you either hand in your mail ballot to your clerk or mail your ballot in, that is not the end of the process, right? It may become a dialogue, and really staying in touch with your county clerk or registrar to make sure that the ballot is received and there are no questions with your signature. That's really the best thing to do, because if there's a question, they then reach out to you as an individual. We have the clerks have until 6 days after election day to conduct signature curing. So that way ballots that are postmarked up to 7 p.m. on election day can still arrive at the county. They can still go through that same signature verification process. And if there's a question at all, the clerks have until the 6th day after the election to conduct that signature verification, to reach out to the individual, to allow them to come into the clerk's office and to otherwise cure the ballot or cure their signature to confirm, yes, that is my ballot, that is my signature. And only then, once that process is done, does it move into the next step where the ballot is separated from the envelope. Does that answer your question?
Yes, thank you. So, excuse me, I just want to add, so therefore, if that person does not get back to the election department, they really have lost their vote. Yes,
that is exactly right. That's part of the reason why this process in its entirety, the signature verification, is something that we take very seriously. It's important that we recognize both that the signature is a gate, right? We want to verify the signature of the voter before that ballot is cast. But along those lines also, we want to, if there's a question, and again, we default to, if there's a question, then you need to ask the voter to confirm it. Because and then aggressively reach out to the voters to try and get in touch with them, because you're right. Someone that casts a ballot thinks they did the right thing, thought they were involved in this extremely important right, and then goes about their day and never answers the text messages or the letters or the phone calls from the clerk, that their vote doesn't count. In those cases, when again, that it is what it is, unfortunately, but the idea is that it's better to be secure in the process than to risk a ballot going through with the signature does not match anything related to the voter's registration.
Okay, thank you.
Mr. Parks, are you back yet? Perfect. Mr. Parks, you mentioned before you have some public comment.
Disregard, please.
Yes, sir. Is there anybody else that has comment on proposed regulation R106-21? Seeing none, I will close public comment on proposed regulation R106-21 and open the workshop on R107-21. Proposed regulation LCB file number R107-21. Existing law requires, with certain exceptions, a county clerk or city clerk to prepare and distribute a mail ballot for every election. To 1, each active registered voter in the city or county as applicable, and 2, each person in the county or city as applicable who registers to vote or updates his or her voter registration information not later than 14 days before the election. Existing law also authorizes a voter to elect not to receive a mail ballot by submitting to the county or city clerk a written notice which must be received not later than 60 days before the election. Section 2 of this regulation authorizes a registered voter to elect not to receive a mail ballot by submitting such written notice to 1, Secretary of State, who will notify the applicable county and city clerks, 2, the county clerk, who will notify the applicable city clerk, or 3, the city clerk, who will notify the applicable county clerk. Section 2 further provides that if a voter has previously elected not to receive a mail ballot, the voter may submit written notice that he or she wants to receive a mail ballot in future elections. Section 3 of this regulation provides that if a registered voter updates his or her mailing address in the voter registration information after the date on which a mail ballot has been sent to the voter, but not later than 14 days before the election, the county or city clerk, as applicable, must cancel the first mail ballot and on or before the 13th day before the election, send the voter a second mail ballot to the updated mailing address. All right, at this time, I'll open public comment regarding proposed regulation R107-21. If anybody is interested in providing public comment regarding this proposed regulation, please go ahead and indicate so now. So, Mr. Beatles, please.
Yeah, thanks, Mark. So this one here authorizes a registered voter to elect not to receive a mail ballot by submitting such written notice. But again, this is one of those things that if you look at the voter rolls, just in Washoe County alone, we started off with about 38 to 42% error rate. Now we're up in the 50s. So that means that you're literally sending out masses of ballots to incorrect people, ghost voters, whatever you want to call them, that are just flooding the system with all of these ballots. If you're going to mail out ballots, then they should only be to people that request them. Why in the world would you just arbitrarily just send people a bunch of stuff that they may not be, number one, qualified to receive, or number two, even asked to receive it? So that's one of the big things right there. I mean, if we just go to in-person voting, this all goes away. Why are we allowing all these issues that we know all these other countries prohibit? Why are we doing it?
Thank you, Mr. Beatles, for your comment. Again, just a reminder, it's in the statutes. We don't pick and choose the laws we follow, but I do understand your comments, and we'll mark them down as such. But thank you for your comments. Ms. Martinez, please.
Yes, thank you. Again, Cindy Martinez for the record, Vice Chair of the Washoe County Republican Party. If I understand correctly, the process of requesting to opt out of participating in a having trouble here, of receiving a mail-in ballot, as I checked in with the Washoe County voter registrar, was then I would be required to vote on the election electronic unit. So on one hand, there's an actual paper ballot that I can keep track of as far as it having a serial number. I can make a copy of it. I can take a picture of it. Not that I can ever look at it again. But the point being is that I lose physical possession of a document that is the only record of my vote. Am I misunderstanding that? Because they said that I would not have a paper ballot if I opted out of the mail-in ballot. So then I'm relegated to carrying my sample ballot with me and then voting on the electronic machines, which respectfully, I don't trust.
Yes, ma'am. I think I understand your question. If you, the paper, I'm sorry, the mail ballot, if you opt out, you will not receive that one. And just for everyone's continued awareness, that the opt-out form as it currently exists is at the very top of the link I just provided. If you opt out of the mail ballot, you won't get that ballot. You will still get a sample ballot though, that you can then review your choices, identify who you're interested in casting your ballot or your vote for, and you can carry that sample ballot with you to the polls to vote. Again, depending on the county where you're at, using the system selected by the county. If you're concerned about having like, I guess maybe if an alternative, if you don't want to mail your ballot in, you can still receive the mail ballot, fill it out, and then hand carry it and deliver it directly to your clerk or registrar as an acceptable alternative as well. Does that answer your question?
No, I understand the points you're making and I agree with those in principle. The problem is though, is by offering a voter the option to vote, to opt out of receiving a mail-in ballot, which in theory would eliminate the possibility of it being intercepted before it arrives into their mailbox or their possession, correct? But then by doing that, then the voter does not have a paper ballot that is representative of their vote. So if I take a mail-in ballot, and personally, I'd hand deliver mine directly into the registrar voter. I don't drop it in the mail. I don't put it in a ballot box. I deliver it, and I have the benefit of living in town to do that. But the problem is if everybody's going to be required to receive a mail-in ballot, regardless of whether they request it or not, and then they have the option of opting out of it in order to protect themselves from it being misdirected, then they are left with the only option of using an electronic mail voting unit. And the vulnerability obviously are in several points along this process, but with not having and the sample ballot, that's great, but that's not the final document, the official document as evidence of one's vote. So that's a vulnerability. And of course, as Mr. Beatles and Oscar and many of the other people on here have stated, and yes, I know that that's the law, but this is our opportunity to register our dissatisfaction with a flawed process that leaves our votes unsecured. That's my point being. Thank you.
I understand. Thank you, Ms. Martinez, for your comments. Ms. White, please.
Thank you. I'm just wondering where I might be able to find the information about universal mail-in ballots cost. Where can I find that, maybe for just the last election? Because of course we don't know what it is now. And then two, these recommended regulations surely are going to result in additional costs. Are they unfunded? I mean, where's all the money coming from that's gonna support the stuff that you're proposing? And third, on the opt-out form, is there any kind of signature verification done on those? Thank you.
Yes, ma'am. Let's see if I captured your questions. Funding for the regulations, again, these regulations are merely supplements to the statutes that are existing. So funding that was allocated for the statutes will cover the regulations. If at all, you'll notice that, again, many of these processes, like the opt-out process, involve a digital form, transmitting it as an individual voter to the county, so that there are no, again, identified costs to the state for any of these proposed regulations as they currently exist. If amended, and there are costs, again, there's a requirement for an economic impact statement and a small business impact statement if they're going to adversely or positively affect anybody across the state. And you'll notice those are included in the notices as well. In regards to signature verification of the opt-out forms themselves, no. If somebody submits an opt-out form and signs it, again, if there's questions on the form itself, the county clerks and registrars will reach out to the voter to clarify their questions. But otherwise, there's no intent for a signature verification process. Which I believe I think those are all of your questions. Did I miss anything?
Well, I can just foresee lots of problems coming up, because if people fraudulently submit ballots, it's possible that they could fraudulently submit opt-out forms, and then you're going to run into major problems at the polling locations. And then the other thing is, as a teacher, retired, I encountered more responsibilities being placed on me every day, every time we had a staff meeting. And, eventually you ran out of the 40 hours and you went into the 50, 60, 70 hours per week. And so the processing required for these opt-out forms is just adding another responsibility onto the registrar workers. So it does have an impact on funding. So it's not like we're just saying, oh, they're just doing their job regularly. Overtime is going to be required. There's going to be more technology support required. It does have an impact on funding. Thank you.
Yes, ma'am. And I apologize. I understand what you're saying. And there's a couple parts of that as well. One, it's in the statutes, so it is a requirement, and the clerks and registrars are all aware of that. Two, they have discussed the increased requirements across the election bills that were passed during the 2021 legislative session. Some of the clerks have the staff to address them. Some of them are pursuing new positions, and they're doing that at the county level, recognizing fully that like you said, that there's only so many hours in a day, and with a limited number of staff, they need, in many cases, more staff to address these requirements. So I think you hit the nail on the head there, and that's something they are all keenly aware of. Absolutely understand. And the last part on the opt-out form, there is a requirement that the opt-out form be submitted 60 days prior to the next election. For everyone's awareness, again, as we look forward to the primary, the 60-day form or 60-day deadline before the primary election is on April 15th of 2022. So if you or anybody that you know of is interested in opting out, that form has to be submitted to the clerks no later than 15 April 2022. If you submit it on the 16th April, the clerk will still receive the form and process it, but it will apply to future election cycles and not the immediate next one. But that is also part of the process. As you can imagine, there's a slightly decreased requirement of the clerks and registrars to process these forms from 59 days on to the election. At that point, again, because it's going to be applying to the primary election or any special elections that occur in between the primary, to the general election or any special election that occurs between the primary and general, there's a slight reduction in the urgency of those forms. But I appreciate your comments and certainly have them noted down. Thank you. Mr. Beatles.
I'm sorry, just one last thing. I've learned so much from your comments and it's been so helpful. So thank you for these workshops. But how is the information, like these dates you gave me, like that April 15th deadline to submit an opt-out? I would not have known that. I just wouldn't. So what is your office or the Secretary of State's office, or what are you telling voter registrar's offices to do to notify the public of these changes and these dates and everything else? It seems like it should be a proactive campaign to update the constituency, not something that is just available if somebody happens to run across it. Thanks.
Yes, ma'am. To answer directly, we're doing everything we can, recognizing our internal staff and resource limitations, but we are trying to be very proactive in notifying the public about these timelines and deadlines. I have an elections calendar on my wall that we update every year, every election cycle. It's in like a 6-point font because there are so many deadlines and requirements that are defined by statute and regulation. So yes, we do everything we can to notify the public to be proactive so that people can opt out. So they're not hearing about it on day 59 going, I wish I'd known about that beforehand. And certainly, again, a humble request on my part, please, if you have people that ask you questions, if you discuss elections, please mention the opt-out form. Please mention the deadlines. Please mention these processes we've talked about. Or again, if it's frankly easier, send them to nvelect at sos.nv.gov, and I will schedule time to talk to them to help provide this information.
Is that calendar you referenced available to the public?
It is, yes, ma'am. We're actually in the process still of updating the 2022 elections calendar because of the number. There's over 10, it was 10 bills that were passed with a lot of dates, and we want to make sure it's right before we put it out. But yes, ma'am, absolutely.
And can you provide that link, please? Thank you.
The same link, the 2022 elections information link. Everything that we have, when it's finalized, will get posted on that website. So if you check there occasionally, it will be updated.
Okay, thank you.
Okay. Mr. Beatles, do you have another comment?
Hey, Mark, I had to step away. Are we on 108-21 yet, or are we coming into that next?
Momentarily.
All right.
Possibly, depending on the comments. But yes, sir, thank you. Are there any other comments regarding proposed regulation R107-21? Mr. Williams, please.
Hi. Why I know the NRS prohibits it, but why can't we forward a ballot to the known new address of a voter that's moved by certified mail by return receipt? Why can't we forward the ballot to a known new address of that voter? You're not allowed to forward the ballot. You got to take the ballot back, cancel it, and then send a new ballot. And that's kind of a waste, I think. And I don't, because if you got certified mail return receipt, the guy's got to sign for it. And we got signature verifiers down the county and can go, oh yeah, cool. And so it's just a thought. Why can't, even though I know the NRS prohibits it, would you please expand your thoughts on that? On what I should have said, my opinions.
Thank you for your comments, Mr. Williams. The NRS prohibits it. The NRS prohibits it.
I know, but we could do it another way and save money. And I mean, we have, if it's a known address, I mean, it's just some certain efficiency. We got the technology to do it. And you guys love technology in our election. So here's an opportunity to do something to enable voters, right?
Certainly something for consideration, either as a BDR for future cycles.
Thank you, sir.
Sir. Is there anybody else that has a proposed, public comment regarding R107-21? Then at this time, we'll close public comment on proposed regulation R107-21, and we'll open the workshop on proposed regulation R108-21. Proposed regulation R108-21. Existing law requires the county or city clerk to allow members of the general public to observe the counting of the ballots at the central counting place, if those members do not interfere with the counting of ballots. The central counting place is the location designated by the county or city clerk for the compilation of election returns. This regulation, 1, authorizes with certain limitations any person to observe the processing and counting of ballots at the central counting place. 2, requires that before a person may observe the processing and counting of ballots, the person must sign an acknowledgement that certain behavior is prohibited at the central counting place. 3, authorizes under certain circumstances that the county or city clerk limit the number of persons observing in the central counting place. 4, authorizes under certain circumstances the county or city clerk to remove a person from the central counting place. And 5, requires a person to wear a name tag while observing the process and counting of ballots. At this time, if there's anybody, I will open public comment on proposed regulation R108-21. If there's anybody that has desire to provide public comment on this proposed regulation, please indicate so now. Mr. Beatles, please.
Yeah, thanks, Mark. So, we already emailed this, Oscar team, myself, we put together a bunch of stuff, sent it to you so you have it, but I just wanted to touch on a few things here. So this here is really, really broad and kind of puts all the power in the county or the city's hand to limit who can come and view publicly. Is there going to be a ratio that applies to this? Is there going to be an attempt to allow balanced numbers of partisan viewers? And why is the ACLU and organizations such as that, allowed to do this and to not be treated like the rest of the public? We saw that in Washoe County. We had people from San Francisco, from the ACLU, working our county elections. And that's just wrong when we have so many people here that wanted to do it, that weren't allowed to do it. Then another question I got is, I'm getting reports now that the Secretary of State, register of voters, county clerks, whatever, they're saying now that poll workers, even poll observers, managers, they're requiring vaccination. Is that true?
Mr. Beatles, thank you for your comments. So a question in regards to poll worker vaccination requirements, is that what you're asking?
Well, that's one of them, sure. So number one, obviously, how do we know how are we going to be treated fairly? Because last time we weren't. You had people from San Francisco and the ACLU working our elections, which is uncalled for because we had plenty of volunteers that weren't allowed to do it. And then secondly, we're getting reports that you guys are going to require proof of vaccination to work these polls. Is that true?
So no, the Secretary of State is not going to create requirements for poll workers outside of the those identified either by the state level, like specifically the governor's emergency directives, or those county requirements that the county commissioners may identify leading up to an election. I will tell you, I have been asking, and I do not have any answers that indicate any county currently requires poll workers to be vaccinated. So as it currently stands, that is not the case that I have heard. And I am asking and keeping an ear open for that. In regards to, excuse me, in regards to observers at the polls and who's allowed to observe, again, to make sure that we're being very clear, this is separate from poll workers, right? Again, an observer is one thing, a poll worker is somebody different, there's a different role. This is also something that we've had some extensive discussions on over the last year. Again, numerous factors that we have to be mindful of and consider. Everything from the physical locations. There are limited spaces in some of our locations where people want to observe that physically can't handle more than 2 or 3 people. Others are much bigger and can handle more people. How do you, again, identify, and we've discussed this again at length, what's the best way to make it even and fair and equitable so that folks that are involved in this process that want to watch, and then again, the clerks are eager to allow transparency. No one at all, from the secretary, again, through the elections division to the clerks and their staffs, is trying to hide anything outside of your privately identified information. I should clarify, so that we're not spilling your information and having foreign and domestic actors get credit cards with your info or whatever. So how do you do that though? How do you, we had discussions about allocating certain seats for certain parties. Is it major parties get a seat, or maybe if there's space, get 2? Or what about minor parties? Should they get 1 seat during certain times a day? What about high school students that want to observe? Do we just keep them out of the process completely? Of course not, right? Because you have folks that want to observe. Many are Nevada residents, many are registered voters. But when it comes to the observation, again, the goal is transparency for everybody without an obstacle. So that if somebody comes across state lines and wants to observe from another state, they're allowed to do so. And again, should not be prohibited. Along those lines also, we discussed vacancies. What if we allocated certain seats to certain parties at certain times of day? Well, if it's certain times of day, then there's going to be questions about which is the most important time of day to watch, because people will be concerned about that as well. How do we make that even? How do we, if somebody doesn't show up, supposing a seat left open for one party doesn't have anybody sitting in it during that day, are we allowed to, can we give that to somebody else to see? But what if somebody shows up? Are we then kicking somebody out? These are very complex discussions that we've had with, unfortunately, no real easy answer. Outside of, again, as indicated in this regulation, there were clear individuals, and again, not across the board, not uniformly. This is a very small number, thankfully, of individuals who came in to be observers, read what their requirements were, and then blatantly and brazenly violated those rules and tried to disrupt the process. Whether for whatever reason that was. At what point should one of our clerks or registrars, and this is a bit rhetorical, stop focusing on the conduct of an election at the county level and making sure that things are moving smoothly and that lines aren't long and the ballot drop boxes are being emptied according to the schedule. And as anybody that's ever dealt with any sort of complex, time-intensive, process or program or operation like this would know, like it's complicated. You have to have oversight. There's things that are happening that need addressing constantly. Should your clerk or registrar stop what they're doing and go over to adjudicate somebody that maybe read this as an observer and then is deliberately violating it? How many hours of the day should we require a clerk or registrar to keep somebody, to warn somebody, sir, ma'am, this is the 5th time I've asked you to stop recording. You're not allowed to have a phone in here and record this information. Sir, ma'am, would you please stop yelling at voters? That's not allowed under the requirements. So these are, again, discussions that we've had. Again, I'm eager to hear your comments. I see a handful of folks that have hands up, and I very much like to hear that. But please understand, again, this was not a fly-by-night sort of discussion that just kind of happened.
Okay, no, that's great, and I appreciate all that information. But again, when you have official positions like poll workers and poll managers and poll watchers, you can do it bipartisan. You can use citizens from within the county, and we're not doing that. And then you also have in this new regulation meaningful observation. What does that even mean? Because last time we had poll watchers, if they were even allowed to do it, they were 100 feet away. They could watch the fraud happen, but they don't know exactly what happened. So what does meaningful observation mean? And I'm strictly speaking to the actual workers at these polling locations, the managers, the workers, the observers, right? The watchers. So what is meaningful observation, and how do we ensure that we're just polling from the county? Because we have more than enough volunteers. But again, just like last time, they weren't allowed to be used.
So again, this regulation is talking about observers, right? We discussed meaningful observation yesterday, and I have your written comments on that as well.
Yeah, I just hoping for some clarity for everybody because they're all kind of related.
Yes, sir. And again, we have a proposed regulation that describes and discuss meaningful observation. And in fact, we talked about it yesterday, but we are going to talk about it again in a future workshop on February 4th, and then in a follow-on adoption hearing as well. So there's still plenty of time to receive comments and feedback. The notices that I put into the chat do include the description and definition of meaningful observation for those that have questions on it. Otherwise, I think, Mr. Beatles, thank you for your time and your comments.
Thank you.
Mr. Sackerson, please.
Yes. Regarding R10821, section 1.3a, in lieu of the original provision, I would ask that you consider to strike it in its entirety or reword to assure that there is at least one observer from each political party with a minimum 0.5% participation in that election. The participation level can be calculated from the registration information derived from the election cycle maintenance and, probably correlated to the 90-day blockout period. Then my other comment is on section 1.4, and that is to request that it be reworded to assure that the observers are allowed effective access and proximity to the signing. That would include the signatures themselves and the signature verification process. Observers must effectively and diligently witness this heart of the election process in order for citizens to accept election integrity. And as a note on that, back in the dark ages, I was a poll watcher on a couple of national elections in the good old days when everything was done on paper, everything was done with photo IDs and the whole 9 yards. Anyway, thank you again.
Yes, sir. Thank you for your comments. Definitely taking into consideration. Ms. Thomas, please.
Okay, why doesn't the Secretary of State require observers to be registered with the state along with the state's form that they have to sign? This would remove the responsibility and paperwork from the county polling locations to manage this. Poll workers have no way of verifying which party this person truly represents in order to maintain a balanced and fair opportunity for all observation. Many polling locations have limited space, and it's just not feasible to have more than 3 to 4 observers at a time. There needs to be a central database where poll workers can verify and affirm observers. It would be ideal if a reservation system was online as well. Observers could see where the need for observation is available before driving to that location, as well as plan their schedules more timely. Some observers like to visit several locations throughout the day, while others prefer just one.
Thank you for your comments, Ms. Thomas. Absolutely, we'll take that into consideration. And online registration and understand the rest, again, in regards to register with the state instead of the county. But thank you for your comments. We'll definitely take into consideration. Mr. DeGraffenreid, please.
Thank you. For the record, Jim DeGraffenreid. I am Nevada's Republican National Committee man. Meaningful observation is a cornerstone of fair elections. And if we don't have meaningful observation of the vote count and the signature verification, it's impossible to have faith that all ballots were cast and counted fairly. I'm sure that all of us here share the same goal of free, fair, and transparent elections. And so the bar for limiting poll observers must be set very high. In section 1, subsection 3, we suggest changing the arbitrary power given to election officials to, quote, limit the number of persons in the central counting place, end quote, to be more specific, and to mandate that in the event observers need to be limited, and we certainly understand that there are fire capacity concerns, for example, it has to be proportionate to the Nevada electorate, which is 1/3 Democrat, 1/3 Republican, 1/3 nonpartisan or unaffiliated. This allows voters of all political persuasions an equal share in oversight and observation. And then once again, we assert that a great way to ensure meaningful observation is by providing online broadcasts of the counting and verification process statewide, as is currently done in Washoe County. This allows all citizens to observe the process and also addresses many of the capacity issues that you raised a few minutes ago about how to decide who gets a seat at the table. Surveillance systems, as we use here in Nevada at casinos and convenience stores statewide, is cost effective and it solves numerous issues with transparency. Thank you very much.
Thank you, Mr. DeGraffenreid. Appreciate your comments. Definitely take into consideration. Ms. Benson, please.
Hi there, thank you. For the record, Alita Benson, Political Director, Nevada Republican Party. One concern on the proposed regulations is section 1, subsection 4, that would allow poll observers to be sequestered to a designated area, which does not often permit viewing of the overall counting process. For example, in 2020, during the 2020 election in Clark County, the election department did not allow poll observers or poll watchers to view ballot duplication, adjudication, or signature verification. Counting observers must be allowed to view the entirety of the process, including processing the ballots, counting the ballots, duplication of any ballots, adjudication, and storage in order for it to be meaningful. Second, the secret ballot is the cornerstone of our elections, right? There is a serious concern if the same person who checks the signature on the outside of the envelope can then also be the person who opens the envelope. This poll worker now knows who that voter voted for. This is no longer a secret ballot. We recommend an addition to the regulation that mandates it must be a separate election worker to review signatures than the person who opens the ballots. For best practice, the ballots would be required to be face down when opened to minimize any chance that the violation of a secret ballot occurs by a poll worker inadvertently seeing a signature. Our goal is transparency and a secure election, and ensuring observers of all parties have the ability to observe and that voters can have confidence that no one has the ability to know who they voted for is a key aspect to a free, fair, and transparent election. Thank you.
Thank you, Ms. Benson. Definitely take your comments into consideration. Appreciate your time today. Ms. White, please.
Thank you. I've not worked in an election before, but I will this time. So I'm not familiar with this answer. It says in here that the observers cannot speak to any employee in the election division. So if there's a complaint on something they observed, there is one designated election worker to whom those observers are supposed to report and lodge their complaint. Okay, that's good. And then the second thing is, it would be good to have in here someplace that no physical barriers should restrict observation in any way. I mean, pizza boxes or chairs or filing cabinets or whatever, it should allow clear observation. And Mr. DeGraffenreid brought up something. I'm not sure why cameras and phones and computers would be prohibited. I mean, if they're silenced, they're not going to interrupt anything. And if it's a question of privacy or whatever security, I mean, have the mandate the counties to install recording cameras for every process along the election ballot opening and tabulating, every single one with unobstructed views, and with audio would even be better. So I don't understand the phone thing. I mean, if you have all the observers who are recording with their phone what's happening at a time when there was an objection filed with the designated election worker, or just noticing something that doesn't look right, it would be evidence, not just a description. So can you tell me why the cameras and computers are prohibited? Thank you.
Yes, ma'am. Again, the requirement is defined in statute and in regulation. Again, in part to preserve the integrity of the privately identifiable information. This is something that, again, we're not saying no to by any stretch of the imagination. We're still considering and looking very closely at other states and different processes. Washoe County, for example, again, has utilized surveillance cameras very successfully. So we're trying to get our hands around what that cost would look like and different implementation ideas. There are concerns that I've talked to, again, mentioned yesterday, some of my counterparts in other states have identified that the implementation needs to be done properly, so that there's not, well, a simple case in point. If you put up a surveillance camera and then make that link available to the public, if you haven't prepared for a large surge of individuals to watch it, which I guess maybe sounds a bit silly to not anticipate that, it can crash, creating further voter frustration. So there's concerns about that. There's cost issues in regards to the maintenance. Again, none of these are obstacles that would be prevented from occurring with possible changes in statutes or future regulations, but what are certainly things that need to be identified before we attempt to implement it, so we're not just jumping into things. There was also at least one location I remember hearing about where they bought top of the line cameras and didn't realize that, that you can actually zoom in so that people's information on the screens, including like names and addresses and those sorts of things, could have been recorded, but they caught it beforehand. So again, there's a lot of factors to take into consideration, but I definitely appreciate your concerns and we'll make note of your comments. Mr. Williams?
Hi, this reg is almost identical to R098, which I know was talked about yesterday. Why the two regs? They're really identical. So can you explain that to me, please?
Yes, sir, I can. One moment, let me pull R098 up and I will quickly review it so I can provide an explanation of the differences.
That's greatly appreciated. Thank you.
Oh, I see. So when we propose regulations, part of the intent is to make sure that the regulations that are basically grouped together appropriately, and if it you wouldn't necessarily want to have, for example, a campaign finance regulation incorporated into one that talks about meaningful observation, just as an example. As part of that development process and in the drafting, if it's determined that there's enough difference between subjects it warrants breaking out, specifically for 9.8. That's the one that talks about, again, that we reviewed yesterday and that we will again review on February 4th and February 22nd about meaningful observation. That is separate. And while there are some elements that relate to, because this is still talking about NAC 245, the one that we're looking at today, this one, proposed regulation R018-21, is creating creating a new regulation. Does that make more sense?
Yeah, it does. It just seems a little duplicative, and it's quite curious to use the words creating, because that sounds like lawmaking, but your call, sir.
Creating regulation. Yes, sir. That is, we're adding into the administrative code a new section in that regard. But yes, sir. Is there any other public comment on proposed regulation R108-21? Okay, seeing that, I'm going to close public comment on proposed regulation R108-21. And open the workshop on proposed regulation R109-21. Existing regulations require, after each election, a county clerk to conduct a post-election certification audit of a certain number of voter verifiable paper audit trail printers, known as VVPATs, that are randomly selected to ensure that the paper record produced by a VVPAT accurately records all votes cast by voters on a mechanical recording device. A VVPAT is the device attached to a mechanical recording device and the paper it prints to record all votes cast by a voter for any and all candidates and for or against any and all measures, enabling that voter to visually verify that the mechanical voting system has accurately recorded the votes of the voter. This regulation provides that if a discrepancy of 4 or more votes is discovered during the post-election certification audit, the county clerk must immediately notify the Secretary of State and investigate the cause of the discrepancy. If the discrepancy cannot be resolved, the county clerk must randomly select an additional number of mechanical recording devices with attached VVPATs used in the election to audit. This regulation also requires that the county clerk to include in the audit results transmitted to the Secretary of State an explanation of any discrepancy discovered by the county clerk, and if determined, an explanation of what caused the discrepancy to occur. At this time, if there's anybody interested in providing public comment regarding proposed draft regulation, proposed regulation R109-21, I will ask you to go ahead and indicate that desire now, please. 1 moment. Mr. Beatles, please.
Yeah, so the county clerk takes a sampling of the machines for the audit, and then who do they give them to? Who does the actual audit? Is it the Accuracy Certification Board? Also, the type of audit and the methods of auditing, they're not defined. So the applicable law, again, isn't cited. And also, we don't know how much this is going to cost. And of course, we object to, sampling of machines for an audit. We demand that there's hand counting of ballots instead. If the ballots were hand counted to begin with, we wouldn't have these problems that stem from all these machines. And then who decided to have the Nevada Gaming Control Board certify, or I guess you would call them electronic voting machines? How did that come to be to where the same people that I guess certify slot machines are certifying our voting machines?
Mr. Beatles, so in regards to your question, again, no costs. There's a number of pre, during, and post-election audits that occur automatically already. So there's, again, no cost incurred by the state or counties by adding in an additional audit. In regards to the discussion about the Gaming Control Board, unfortunately, because that's not part of the regulation, we could certainly talk about it separately. But again, it's, I guess I hear your concern, but I'm again, outside of really discussing it outside of this venue, because it's not really part of the agenda or this regulation, I don't know if I'd be able to right now. Perhaps we could set up some time to discuss it at a future date.
Sure. I mean, it talks about auditing of the machines. So I figured since we're auditing machines, how do we know they're trustworthy?
Oh, I see. So I guess a little bit of background then in the Gaming Control Board in that regard, I think is valid, because we bring up audits, we talk about auditing the machines. That gets in a little bit to some of the EAC certification process, I think, as well, and the state and county level certification process, which then gets into where the Gaming Control Board comes into involvement. So this goes to the requirement to have a neutral third party review voting systems. The way, well, this that kind of gets into a bigger discussion that may exceed the scope of our discussion today. But how about we do this? I can set up time with you to discuss the EAC state and county level certification process that explains where Gaming Control Board personnel kind of fit into the picture. That would be something that we could discuss separately, and that way anybody that's interested in hearing that or being part of that discussion would be able to attend. Could we do that?
Yeah, I mean, we'd love some clarity as to, I mean, when you think of the casino and the gambling industry, obviously certain things come to mind, and it's been shown over, over the past decades that a lot of unscrupulous things happen, and these are the people that we're counting on for these voting machines. So obviously there's some concern there. Not to mention other things that we found that I'm happy to discuss as well.
I'd very much enjoy that. Please, again, ndelect@sos.nv.gov, or perhaps reply to the email that I sent to you confirming receipt of your written testimony, please. Mr. Hindle, please.
Yes, thank you, Mr. Velasco. Again, for the record, this is Jim Hindle, Vice Chair of the Nevada Republican Party. We have a suggestion for the improvement on proposed regulation R109 in sections 1.3, 1.4, and 1.5. Currently, the standard for post-election audits is set in the single digits. I don't think we want to get into a statistical discussion here about minimum standards and distributions and random samples. But I think we can agree that a premise today is that we should go beyond minimum statistical standards for increased reliability and confidence in our system. So we request for confidence that the audit minimum be set at least to 10% of a sample of 10%, with election officials certainly encouraged to do more. Second, getting the audit results from county clerks or registrars is currently a challenging process requiring Freedom of Information Act requests that may or may not be answered depending on the elected official and their adherence to NRS. We've had issues with that in the past, and we can talk about that offline as well. We would suggest that any audit result be published in detail to the public, posted via electronic posting or electronic notice, and kept up for a minimum of 90 days. We think that the transparency of this is very important to providing greater confidence, as well as to greater education of the public as to how the audits are done and what is being looked at. Again, as we talked about yesterday, given the concerns with electronic machines, with electronic voting, with mail-in ballots, et cetera, anything that we can do to increase confidence and increase transparency, I think we should go forward with, and we hope you'll consider these recommendations. Thank you.
Thank you, Mr. Hindle. I appreciate the comments. We'll definitely take it into consideration. Ms. White, please.
Thank you. There are audits and there are audits. Now, if you're just using the term audit to refer to the reliability of a mechanical device, which I assume these VVPATs are, that's one thing. How many times am I going to stick a piece of toast in the toaster and it's going to toast it? That's one thing. But as far as using the term audit to try to increase voter confidence in election integrity, it's not really an audit. What it is a check of a mechanical system. It's not an audit in any definition that I would use to increase or have more trust in the election count. So maybe different terminology can be used. It's just, if you're going to do an audit, it should be a visual audit. If you're just testing the reliability of a mechanical device, that's not really an audit. So I don't know if any clarification or additional language can be added to that to define what the audit is supposedly going to prove. Thank you.
Thank you, Ms. White. I appreciate your comments. Yeah, we'll definitely take it into consideration. In part, we use the term audit, again, at least for your awareness, it's already in existing statutes and regulations. The term audit has been in there for some time, and certainly before the more, kind of the idea of like quote unquote forensic audits has come up recently. But I understand your concern and desire to hear and understand more about what is expected out of an audit. Or again, trying to find perhaps a different term to use to clarify the different types of reviews, because there are a number of other things. You're right. As part of the certification process, for example, it's not just a simple review of like does the machine turn on and off, like exactly kind of what you're saying, right? Like we scrutinize a great number of things. Members of the Gaming Control Board, again, even look at like code to make sure that the code matches exactly what is said to do. Any modification ever, before a voting machine gets in front of a voter, that modification has to be proposed to the EAC. The EAC or one of their certified vendors has to review it to make sure that it meets exactly those expectations and nothing beyond it. When it comes to the state level, we conduct a review of these things as part of our certification process, and that includes everything from, again, looking at the technical code, physically looking at the components inside the machine to make sure, for example, there are no modems or other items in there that are not allowed in Nevada voting machines. But you're right, more clarity, I think, is the desired recommendation. So I appreciate that, and we'll make note of it.
Yeah, I just want to follow up where you mentioned reviewing code. Dominion, I know their code is proprietary. They don't share it. So there's no way that we can confirm that what their software is doing is really what they're telling us it's doing. So, I mean, that's just another reason to not certify these electronic voting systems. And it would just be nice, because it seems disingenuous to use the term audit when communicating with the public, which is tending to make them believe that, the check was done so that you're sure your vote counted the way it was supposed to, because that's not what it is when they're just checking the reliability of a mechanical device. Thank you.
Thank you. Mr. Kampf.
Thank you. For the record, Mark Kampf, candidate for Nye County Clerk. I spent 14 years as a forensic auditor and audited some of the largest companies in the world. One of the concerns I have with this is that this process is really a comparison of what is put into the electronic system to the paper. So in other words, a one-for-one match, what somebody intended to have as the electronic vote that has been put in as on the paper. However, it provides nothing for the tabulation of those paper results in comparison to the total tabulation of the electronic system. That's critical because, as we know, there's a possibility for changes in the tabulation. That's been proven in the state of Michigan, that the tabulation process did not match the individual voter process. In addition, once that tabulation is verified, that needs to be reconciled with the totals that are in the Secretary of State system. So for this to be truly an audit, this is just a checking of paper. But once you have an electronic system that is connected to the internet through the systems that provide access to the registration, there's a potential for those systems to be manipulated. And without that comparison of the tabulation of the totals, this cannot be a complete audit. So I highly recommend that this be strengthened to include tabulation of the totals from those machines and comparison to the totals that are included on the database from the Secretary of State, because changes can be made in the transmission between the county and the Secretary of State's office. Thank you for listening to me.
Thank you, Mr. Kampf. Again, for clarity's sake, we don't just audit the day-to-day. We do audit total tabulations to make sure the numbers line up. But again, not in the scope of this regulation, but we can certainly talk about that at another time if you're interested. Ms. Martinez, please.
Yes, thank you. Again, for the record, Cindy Martinez, Vice Chair of the Washoe County Republican Party. At the outset, I've got to confess that I am a little embarrassed that I did not know that the Gaming Control Board was conducting the verification of the electronic voting systems. I retired from the Gaming Control Board Enforcement Division, and I corresponded with a couple of former co-workers last night, one of whom had been queried about that and did an internal questioning of the technology division chief, who refused to talk about that. And then a former co-worker who was completely unaware that this was part of the oversight provided by the Gaming Control Board. Now, I find that problematic if the technology division is primarily responsible for the oversight of the gaming industry, and in particular, NGC Regulation 14. And having been engaged in many investigations, coordinating with the technology division and actually having taken gaming servers down to the lab in Las Vegas. And I've been in the lab, I've been on the bench, so I have an understanding of what the process is there in Las Vegas. And my question is, how can we rely upon, and forgive me for saying this, but how can we rely upon the verification and certification by my former employer's technology division when I know what their capabilities and their limitations are and what their primary scope of responsibility is? For example, in the last 10 years, the gaming industry has been successful in changing Regulation 14 to farm out the testing of gaming devices for approval out to third-party labs. So when you go into a casino and you play a slot machine and you have a reasonable expectation that those machines have been verified by the Gaming Control Board Technology Division, that's only been done under the oversight of the technology division signing off on the lab. So I have questions on whether that is an adequate and appropriate oversight of a state system, state regulatory body overlooking the election system. And then if they're verifying code, the responsibility is to say, okay, gaming machine X has been submitted with code ABC. by manufacturer 123. And yes, the code does say that they submitted to us what they said it's supposed to, and it meets the minimum regulations. So I have great skepticism right now, but what I'm becoming aware of. And then also, if you factor in the fact that these machines have cellular modems, any means of verification, whether code is resident in the circuitry or the processing systems of a machine, is only good until you plug that in and a cellular modem is activated. So I'm very concerned about the ability to maintain oversight, the confidentiality, the reliability of an audit, as well as if you just talk about what happened in Washoe County, where some of the cartridges were missing in the certification of Washoe County's election. And one of the commissioners voted no to certify that election because of those missing cartridges. So regarding everything that we're hearing today, what I've just shared with you with my historical experience with my former employer, which, you know, I served faithfully, I'm troubled by what I'm hearing about the means of oversight on the integrity of these machines and what an audit might actually yield. Thank you.
Yes, ma'am. Thank you for your comments. And to be clear, they do, Dominion, ESNS, the certified systems do provide that base code and say, here, like exactly what you said, here's what we have on there, here's what it does, and that's what's verified against. So again, it's not just look at it and kind of see what they haven't hidden, basically. And then a comment on the modems. No modems on any Nevada machine, period. Full stop. Anything that's you've heard otherwise, anyone that's told you otherwise is flat out wrong. They just don't understand the process, haven't seen the machines. There are no modems in Nevada voting systems, period. Can't stress that enough because it does come up frequently. Let's see here. Mr. Beatles, Mr. Kampf, you have your hand still up. Is it an additional comment or?
Yes, I have my hand still up.
Okay, yes, please, Mr. Kampf.
I just want to understand, did you say that is the review of the tabulation process done by the county clerk or city clerk prior to the certification of the election, or is that done after the certification of the election?
One moment, please.
And is that the responsibility of the county clerk?
One moment. I'm gathering that information right now, and I'll quickly search through it here, and I'll have it for you in a moment. Mr. Beatles, did you have something also? Or?
Oh, I was just curious because you keep saying that there's no modems in these machines, but you can clearly see there's internet connectivity at these poll locations. And one of the things that I've found over the United States as well is in Washoe County is that they say that, you know, Dominion doesn't connect to the internet, but what Dominion's the software. The Dell all-in-one type machine is the hardware. And so that's how they get around it. And you can clearly see in the Dell that it clearly shows that it has modem features. You can clearly see that the all-in-one there at the polling position is the same one. You can see the manual. You can see it has internet, capability. It has a modem in it. And then the Washoe County, workers are the ones that plug it in. So they kind of hand off all this responsibility. So guys like you can say that. But if you look, the software, you can't audit the source code. All right. So you can't audit the source code. I don't care what you say. You can't. I've seen countless, lawsuits and everything else. They won't allow it, not even at a state level. So you can see some of the basic stuff, but you can't see the source code. And then these machines, you can just look right at the Dell all-in-one machine and you see all the functionalities of it. And then when you go to these polling locations, you can see that they're actually plugged in. It's just grab your phone and just turn on Wi-Fi and you'll see the ability to connect. I mean, it's in your face. Again, I could go into a lot of specifics, but I've already given that to the sheriff, the DA, the FBI, and the DOJ. So I disagree with everything you're saying right here. We're all dumber for it.
I appreciate your comments, Mr. Beatles. We'll take them into consideration. Mr. Williams, do you have a comment?
Yeah, I just wanted some basic questions answered. So what kind of audits does the state perform, or do they rely on the county accuracy boards to provide them with the details at the county level?
There's a number of documents. There's a number of audits that are conducted across the state and county level. because it really doesn't touch, it touched a little bit on the I'll tell you what. In fact, I have a document I'll throw into the chat, and that way you guys can review it. It goes into, it's about a 2-page detail about the numerous types of checks and audits that are conducted across the state as it relates to the before, during, and after electoral processes. Will that work, Mr. Williams? And then if you have any questions on that later, we could certainly follow up about it separately.
Okay, that's fine. I appreciate that. One last question. So the Gaming Control Board, they're appointed by the Lieutenant Governor, is that right?
I'm not sure on the makeup of the Gaming Control Board. I'm sorry.
I'm just looking who's got authority to appoint and salaries and all that kind of thing.
I don't know. I'm sorry.
That's fine. Thank you very much. Thank you. That's it.
I did see one question, by the way, in regards to what is paid. There is a memorandum of understanding, or actually, I believe it's actually a contract between the Gaming Control Board and the Secretary of State that defines what that looks like. So in regards to how much the Gaming Control Board is paid for their employees' time and for that activity. I know our PIO will have that contract and we'll be able to provide it as available. So certainly ask her and she'll be able to get that to you. And I guess in regards to Mr. Kampf, to get to your point directly about tabulations, right? So it's not just a verifying the voter verifiable paper audit trail that the screen and that match each other, that occurs, right? Again, because like I said, when you use a Dominion machine, your vote's recorded in 4 different locations on the VVPAT, 2 on the USB drives, and then 1 on an internal hard drive as well. But also the tabulations, excuse me, at the end of the day, make sure that they add up as well. So that again, numbers of votes cast equate to the totals that are tabulated at the county level, and then as they aggregate them together and get them to the state level to make sure everything lines up. So again, there are numerous checks and balances. It goes back to the simple fact that every vote cast is tied to a registered voter. And not, again, there's no opportunity or ability for a 1950s style ballot box stuffing like you may have heard about otherwise. I think that's about it. Ms. White, yes, please.
Yeah, the integrity of the peripheral hardware is also a concern, as they could have internal components which have not been certified. And the source code for those peripherals, are those also secret/proprietary? There's just a whole lot of confidence put into the hardware and the software of these electronic voting systems that really doesn't deserve to be there, because we can't see everything that's going on. And I would agree with the person who said that there are internet capabilities within the hardware and the software of these peripherals and the main voting system, Dominion or ES&S. And given that there's so much distrust of these voting systems, is it within the power of your team to propose a regulation that suggests the elimination of the use of these voting systems, these electronic voting systems? And if so, what evidence would it take for your team to make that recommendation? I mean, if I went back and if I were told, no, you can't go back and check how many deposits or withdrawals were made in your account, how am I supposed to trust that my balance today is what they say it is? That's what's happened with the voting systems. We cannot see history. We cannot see the calculations. We cannot see anything. I don't understand why they've been certified in the first place. So most importantly, what will it take for your team to make a recommendation and regulations that these machines should not be used? Thank you.
Yes, ma'am. Appreciate your comments. To answer your questions directly, Secretary of State, again, there are statutes and regulations that talk about the certification. And the fact is that we require, as a state, requirements of voting systems that meets or exceeds the EAC's requirements. So again, perhaps I could talk to you about the certification process sometime, what that looks like from the state and county level. to help reassure you. I'll be honest, I suspect not. There's been a lot of information over the last year. You talked about peripherals, for example. And I think that's a great point to bring up, right? Because when people hear voting and voting systems, they kind of mentally clump them all together. Like the machine that you stand in front of with the screen, with the VVPAT next to it, that gets lumped together with an electronic poll book. Electronic poll books have internet connectivity because in real time, they're checking the statewide voter registration list to make sure somebody didn't vote in your county and then walks across the county line and votes there. That electronic poll book is not connected to a voting machine, the system that you stand in front of with the VVPAT. The system that you stand in front of with the VVPAT is a standalone, not internet connected system. Mr. Williams brought up a great point too, because this question has come up. Do other states allow the use of modems inside voting systems? Some do. Does Nevada? Almost got unprofessional. No, we do not. No, we do not. And that is something that, again, it continues to come up because other states have allowed it, have changed their requirements, but absolutely under no circumstances is a modem allowed into a Nevada voting system.
Okay, you just said something that I find terrifying, that those electronic poll books, it's a device actually, are connected to the internet. So those are very capable of being entered, whatever the technology term is, and altering the voter registration right there. I mean, I don't understand why the entire system, anything used digitally within the elections division is not in a SCIF or whatever they call it with zero internet connectivity. Everything should be absolutely not connectable to the internet. And just because Dominion says, oh no, there's nothing, no internet capability there, that's not enough to convince me that it's a safe system.
Yes, ma'am. And again, even more specifically, so the reason, and to be clear, it receives the electronic poll books. You may remember, or again, I'm not certain on your age, and I apologize for even suggesting that, but once upon a time, really before about 2010, when you would go to a polling center, you would see a huge stack, right? A document of the list of that county polling location. And this is why we had precinct polling locations. The idea was to reduce the amount of people that would come to one location so that in a county, and by precinct, you would go to your precinct voting location. And when I would walk in there, they'd flip through and I would say, go to the last page. It's on the last one, I bet. They'd dump it, flip it over, go to the last page. And that's where they would cross my name off and identify that I was eligible to vote in that precinct. What's happened in order to facilitate increased voter opportunities is by having these things called, again, vote centers that are defined in statute and regulation as well. A vote center, you go anywhere in your county to any one of the multiple polling locations. And that way, instead of having 15 pages of the 40,000 names for Lyon County or 1.3 million names on a printout, and then having to wait, which adds to the amount of time individuals are waiting in line. Again, it's a device that simply has the access to the electronic statewide voter registration list. There's nothing that again, it's not overriding the statewide one. If a single polling e-poll book gets dropped in a puddle, it doesn't short out the entire statewide system. Of course, these machines have extensive cybersecurity as well, and we can certainly talk about that offline or separately. But again, I understand your concerns, but that was part of the intent behind this transition to electronic poll books. And then the last thing I want to mention about the machines, and this applies to not just Dominion, but others. There are organizations that some states have contracted that have set up monitoring stations around voting machines that track emissions, that look for Bluetooth, Wi-Fi signals, across a full spectrum of different signals to see what actually comes out of these machines. And it's not Wi-Fi. Like there's the ones that don't have modems in them don't have Wi-Fi. Ours don't have modems or Wi-Fi emissions that come out of them. But again, right, that gets lumped in with the e-poll books. That gets lumped in with the county's Wi-Fi system because the registrar is in our clerk is in a county building. Folks will go up and be like, hey, I'm in a polling station looking on my phone. There's Wi-Fi here. That Wi-Fi is unsecured because it's the guest account, and that's allowed to occur. But none of those are connected to the voting systems. So again, I understand your concerns. I appreciate your comments, truly. And again, if you want to talk about any of this in more detail, or if I can help facilitate a tour with your clerk or registrar, please let me know, and I absolutely will do so.
Yeah, it's just that you express a lot of confidence in the electronic voting systems and all the peripherals involved. And without a random sampling and investigation, forensic investigation into the hardware of these devices, I don't understand where the confidence really comes from. Just verbal descriptions from the manufacturers is not sufficient.
I agree, ma'am, and I understand. I spent the entirety of my time since October 2020 as the elections deputy, scrutinizing day and night every possible aspect. I'm a fan of the trust but verify, because I don't trust easily. So I have looked very closely at these sorts of things. But I understand conveying that in a meaningful sense, certainly in a fairly short 5-hour workshop, it's hard to overcome, all the things that I suspect you're hearing as well as I am. So I do apologize for that, but certainly available to talk later if it comes up.
Okay, and I'm sorry to take one more clarification. I asked the question, what would it take in order for your team to make a recommendation to 86, the EVS?
Yes, ma'am. So again, the Secretary of State certifies at the state level the voting systems. She would not certify a voting system if she did not feel comfortable and ask all these questions. Again, the question that I'm telling you about now, if she hadn't asked me these same questions and scrutinized and dug into and not accepted the status quo, not accepted, a single explanation, if she hadn't dug into it. But ultimately, the Secretary of State has the ability to certify or decertify systems for use here in the state of Nevada.
Please record and document that the Secretary of State needs to decertify those voting systems based on the fact alone that the source code is not available for public scrutiny. That alone is enough to say, I can't trust these machines. They should not be part of Nevada elections. I don't know how she gets around accepting these machines without being able to view that code. It's just incomprehensible.
Ms. Thomas, yes, please.
I just wanted to clarify that the poll books are merely for checking in a voter. It's only reporting that a voter has checked in at a certain polling location. Then that machine is used to encode a card with a 4-digit that is basically tells the voting machine what ballot to pull up. When you get to that machine and you put that card in the voting machine, it's telling that machine what ballot to pull based on your precinct. So the poll books themselves are basically only reporting that a voter has checked in at a certain location and was issued a voting card. That is all they're reporting. And in 2018, this was significant in preventing a gentleman that came into my polling location that had just an hour and a half beforehand voted at another Raley store at another location in Reno. And we were able to successfully thwart issuing him a card. The system would not allow us to even activate a card for him because it had already blocked all that. On the back end, I worked in 2020 on the back end. Every time a voter is checking in, it is being reported back to the mothership, if you want to so say. And at that time, we were responsible for going in and deactivating the mail ballot for every person who was coming in and voting in person. And in my experience, I noticed at least 3 persons that were able to vote in person and had already submitted a mail ballot. At that time, we went back and pulled out their mail ballot and canceled the mail ballot. Since we prioritized them voting in person, basically canceled out any mail ballot that was received. Now, that was just my experience. I was one of 8 people on that call center. So I am assuming that those folks had just as many of those occasions as I did. But it was imperative for them to report to us when a person checked in, because time was of the essence for us. And in many cases, we were able to let the polling manager to go and pull out the card of the machine while the voter was in the process of trying to vote before they were successful in casting a ballot. So in that way, we were able to thwart many people from voting twice because, like you said, they went up to the state website, couldn't see verification that their ballot had been accepted. So they were being told, people were actually calling people up and telling them that you need to go vote again. And it wasn't one party or the other. I had a Republican, I had a Democrat, I had an independent, all tried to attempt this. So it's not party specific. It's just the craziness of things the way they are right now.
Thank you, Ms. Thomas, for your comments. Mr. Beatles.
Yeah, I dropped a couple links for your viewing pleasure in the chat there. I'm curious what you have to say about, for instance, Kamala Harris. Both of these were Senate hearings, mind you, where they exposed that these machines were hacked in live time and they're not to be trusted. These are two different Senate hearings, both of them explaining how this stuff works. And then ultimately, if you can't audit the source code and you can't physically audit the paper ballots, you have a fraudulent election. Those are Senate hearings. What do you have to say about those, and have you seen these?
Excellent question. I look forward to discussing with you at a different meeting. Unfortunately, as it's not on the agenda, we're not able to discuss it today, but I will review, I promise you this, everything that you've put into the comments and the websites that you've provided to see if they're, again, if they're accurate or to develop an opinion on them. But again, as we want to make sure the right people are in the right room for these discussions, I think it's appropriate to discuss Vice President Harris's comments maybe in a different forum. Thank you. Ms. White?
I'm just wanting confirmation what Tracy said, that if someone votes with the mail-in ballot and then a different day or even same day, an in-person voter shows up and wants to vote, that the mail-in ballot will be rejected, disqualified, and the in-person vote will be calculated, tabulated. That's another terrifying aspect, because legitimate voters who may have submitted their ballot by mail, their vote is ripped away if a fraudulent person comes and says, this is who I am and here's how I want to vote, because voter ID is not required at the polling locations. Is that correct? Was Tracy correct?
In that situation, I suspect so. I'm not going to call Ms. Thomas a liar based on what she had recounted, but I'm going to provide some additional context to clarify. We've had numerous folks mail in a ballot, get a day or two after they mail the ballot and say, I don't know if it's going to get there. I'm worried about the date. Maybe they mailed it in 2 days before the election or something along those lines. Go to their clerk or registrar and say, I mailed the ballot in 2 days ago. I can show you my driver's license. I can confirm my signature. I can prove my identity so that you know who I am. I would like to cancel my mail ballot and vote in person. That's a very legitimate use case that Mrs. Thomas is discussing and has happened. So that, again, it's not your name's Mr. Smith, John Smith, perfect, come on over. We'll cancel all the John Smiths and allow you to vote in person for all. It's a very deliberate process that involves verification of that registered voter before any activity is allowed to occur. So yes, ma'am. Again, your clerks, your registrars, they want to enable and enfranchise people, not disenfranchise people. If somebody gets nervous about their mail ballot, they're not going to say, well, you mailed it in. Sorry, we're going to wait for you to mail it in, and that's all there is to it. Even recognizing now that, again, voting or attempting to vote twice in an election is a violation of NRS 293-780, right? So again, the clerks are saying, yes, I'm going to allow you, I'm going to cancel that one so that when it's not a cast ballot, we're going to protect you from the 293-780 to cancel that and now allow you to vote in person. So yeah. Yes.
I'm not sure you understood my statement. If I, a legitimate registered voter, send in my mail-in ballot, and someone else claiming to be me shows up at a polling place and says, I want to vote in person, and they're given a ballot, that in-person ballot is tabulated. And my mail-in ballot that I sent, me, the true person, it's eliminated. So I trust that, somebody who goes to the voter registrar and says, I don't want to use this paper ballot, please, mark it as dead, whatever. That, sure, but it's the fraud potential that I'm talking about.
I understand, ma'am. Yeah,
and And you're saying that she's correct. So that could happen multiple times.
So that's part of the reason why, again, the check and balance there is specifically the verification of if somebody shows up and says, I'm Miss Valerie White, I have a driver's license that says I'm Valerie White, I've got the address that matches the voter registration info, the signature on the ID matches the voter info that's in the registration database. If that level of fraud has occurred where somebody is purporting to be you, down to the name, address, and identification, yes, I imagine a criminal could do that.
Okay, so you're saying that voter ID, some kind of ID is required to vote in person?
So I'm saying that if you talk to a clerk about canceling the mail ballot that you sent in and confirming your identity to vote in person, that they're not going to take your word at it. They're going to confirm your identity through a number of different ways available to them. Yes, ma'am.
I'm still confused. If the person pretending to be me shows up, do they have to show voter identification, driver's license or whatever?
Yes, the clerk will ask for proof of identity to ensure that the person who says they're Miss Valerie White is in fact you and not somebody just saying they're Miss Valerie White.
Okay, so everyone who goes to vote must show vote ID of some sort.
In the situation we were just talking about, that's the case. If you're trying to cancel the ballot, and then again, when you show up, when you go to the polls and you identify who you are to check in, there's a process in place to confirm identity, right? So they know that it's you when you check into the poll pad. There's, again, complex, yes, absolutely. Are there numerous well then sort of clauses? Yes, absolutely, under the laws. But again, I think we're straying a little bit from the regulation at this point. But yes, ma'am, again, if you feel more comfortable, I can help set up a meeting between you and your clerk, registrar, and I, and we can talk through these processes. Absolutely.
It might have to be a week-long in-service because
it's been over a year and I'm still learning. So
as many invitations as you've extended to us to talk about them.
I'm serious about that too. Yes, ma'am. Ms. Thomas, do you have another comment?
Yeah, I just wanted to clarify that the system does note when voters, the registrar has received a mail ballot for someone. It's when the intake person brings that person up and says that they have received a mail ballot. That intake person is supposed to call into the call center and verify that they do actually have a mail ballot for this person. And that person is not supposed to be allowed to vote. However, because they were so slammed and because there's only one person verifying this, they just ignored that and allowed this person to vote anyway. This is another reason why I think both intake people should be verifying and checking in one person at a time. It should be double checked right there at the desk, not relying only on one person just to sidestep the system. But there are checks and balances in for that. And then when a person did happen to be able to successfully vote in person and have a mail ballot submitted, there was another call center that would actually call that voter up and let them know that we had a mail ballot. And that was not a process I was involved with. So you're going to have to get with the registrar on that. But yes, the system, the poll books were reporting that a mail ballot had been received. They were just being overwritten by the intake folks. And that might be a glitch that needs to be resolved, within Washoe County or some other way. But I strongly encourage having 2 intake people vote and check in one person at a time. They just get so pressured by the peer pressure of the long lines that they just want to hurry up and process voters. But there's several checks in place, yes.
Thank you, Ms. Thomas, for your comments. At this time, are there any other comments relating to the proposed regulation R109-21P? Mr. Beatles, is your hand up or is that from before?
Yeah, sorry about that.
Okay. If there's no further comments, then I will close public comment relating to proposed regulation R109-21P. We are now at the point in the agenda Public comment on for the final general public comment on matters other than the previously listed LCD file numbers. Comments will be limited to 2 minutes per person. Is anyone interested in providing public comment about a matter not on the agenda? If so, please identify yourself and say your name for the record, please.
Yes, sir. Yeah, Robert Beatles, Washoe GOP Central Committee Election Integrity Chair and Precinct Captain 5030. So, as President Jimmy Carter and the former Secretary of State James Baker, they warned us in their landmark, 2005 Carter-Baker Commission report, the best way to stuff illegal ballots into our election system without detection is by increasing absentee and mail-in ballots. The second and more subtle prong of the strategy was to dramatically decrease the scrutiny and then also the certification or verification of this new flood of absentee and mail-in ballots. By essentially taking the ballot verification cops off the beats, the practical result would be a dramatic increase in the number of illegal ballots that would be counted in the battleground states. We can definitely see between the machines, the lack of bipartisan overview and workers, the mail-out fraud, Eric's system of registering all persons, not citizens, the independent testing of these rigging machines is performed by the Nevada Gaming Control Board. Why not simply use voter ID? Why not adopt our petition? It literally tells you how to do everything. Remember, again, your oath to the Constitution as a public servant. And again, you didn't answer my question, so maybe you will this time. We got to know, can you tell us what's holding you and the Secretary of State back from doing what will restore confidence and save a ton of money and make our elections legitimate again? Please let us all know. Thank you.
Thank you, Mr. Beatles, for your comments. Ms. Thomas?
I was just thinking that we may very well have reached a point where the National Guard should be requested to man our polling locations just for the purpose of maybe handling observers. And also, I would still like an explanation of how a provisional ballot is pulled out of the electronic machines when a same-day registration is found to be invalid. How do you go and pull that ballot out of the electronic records of that may have been voted? Thank you.
Yes, ma'am, Ms. Thomas, and I'll be able to provide that for you again following this meeting. But the kind of the short version is that a provisional ballot is a paper ballot. It's not a ballot cast on a machine. Mr. Hindle.
No, we actually process provisional ballots on the machines in Washoe County. So maybe I have to ask the registrar of Washoe County how they pull out the provisional ballots on those machines. I imagine there is a pool of just provisional ballots, but how would you link that voter to that? Because once you give them that card, all that's on that card is a 4-digit number to pull up a ballot. It doesn't link it to that specific voter.
Yes, ma'am. I'll follow up with Registrar Spiegel about that as well. Mr. Hindle, please.
Yes, thank you, Mr. Velasco. And first and foremost, I want to commend you and your effort through this day. I know it's been a long hearing this morning, and you probably need to step across to the Old Bank Bar to wet your whistle after this, because your voice has been going nonstop, and you've been providing good information. So thank you for what you're doing here. Clearly, a lot of discussion today has surrounded the law as it was passed in AB 321. And that is outside the purview of what we can change in these discussions. Highlighting the issues we have with that law is, of course, important. And I know you've been taking notes on that. This, to me, is one of the strongest roles you and the Secretary of State have to play for us. There has clearly been, implemented through law, corruption in our election system. And you are the voices, in addition to ourselves as the public, but in terms of rallying the information and the advice to our legislators, we need you and the Secretary of State to be much more vocal when they are doing things that are going to corrupt our system. Mail-in ballots are a primary example of that. We know that corruption is first and foremost entered into this system by voter registration. And as long as there is no voter ID required at the polls, voter registration is going to continue to be a source problem, especially now that we have mail-in ballots. Second to that is that we have to go through the process that we're going through today, but we're never going to design a perfect system. It's always going to be good, but never perfect. And as a result of that, we know that there is opportunity, risk for corruption, and risk for fraud. Then you're doing your best to mitigate that, but it will never happen to where it's a perfect set of procedures that is going to eliminate any possibility. And we've seen that in the results. So I thank you again for everything you're doing. I thank you for trying to tighten up these regulations in order to define how the law is going to be implemented. But we certainly need the Secretary of State's office to become much more vocal in what is being done to these systems that you cannot perfectly address to eliminate fraud. And I know you do that at the legislative level, but I think it needs to become stronger, and you need to become harder in the voice that you have to give our legislators direction. So I thank you for the time, and thank you for your effort today, Mark. Thank you very much.
My pleasure, Mr. Hindle. Thank you for your comments. Mr. Williams, please.
Hello, I want to reiterate that thank you, Mark. You're amazing source of information, and your openness is wonderful, and I appreciate that too. My question is, are you aware of a claim that's been made that the Washoe County Registrar had a cyber attack that was effective on November 5th, 2020, around 10:15 in the morning? You aware of that? Can you dispel that it didn't happen and that votes were not affected?
If you can give me one moment, I may be able to check to confirm or deny that.
Really, that'd be cool if you could, because there's one of those sort of gray areas. Like I heard this thing, I'm like, well, give them a chance to respond to it. I don't remember pose that question to you properly and give you a chance to respond to it, because we are certainly concerned when you hear from Washoe County. That's where I am. I mean, I don't want that to happen here. And if there's something that we can do, I know the county recently got a new cybersecurity firm, Provicio, and so maybe that'll help.
Yes, sir. If it's okay, Mr. Williams, we'll move on. I'll continue to write down some notes, but
okay. Well, that's fine. Thank you. I appreciate it. Thank you very much. Thank you. Sure. And thank you for your help.
My pleasure. Ms. White, please.
I'd just like to agree completely with Mr. Hindle's comments. Two, I would like to formally request that we decertify the use of electronic voting systems, whether they're Dominion, ES&S, or whatever brand. I would also like to request that we have re-registration for every general election. Just wipe the voter rolls clean, and everyone who wants to vote, you re-register. That would help clean up the voter rolls from all the other issues. And paper ballot elections only that are decentralized. I would request that the Secretary of State seriously consider those options, those changes, to get out of this universal mail-in ballot nonsense. Thank you.
Thank you, Ms. White. Ms. Martinez, please.
Yes, thank you. Mark, I want to thank you very much for your forbearance. This is a very informative workshop, and I appreciate the back and forth. I know that you're collecting information and responding as appropriate to agenda items. And of course, this isn't really a place for deliberation, but I think one of the things that is challenging when we've been engaging with our elected representatives as well as unelected bureaucrats is that we haven't had this back and forth. Similarly, there may be just 38 there at the top. I think there were 47 of us on here. Is that when you consider the volume of voters in our county and the state, many of our people cannot be here. So if you would convey to the Secretary of State and the other people with whom you're going to be deliberating about these regulations, is that just because there are a few people on this call does not mean that the rest of the electorate is uninterested and disengaged. So we do represent, especially we in Washoe County, we have a very interested electorate in restoration of election integrity. And we find ourselves, and being a retired law enforcement regulatory person, understanding that we are under and at the mercy of overlapping and sometimes in conflict regulatory agencies, which it's difficult to reconcile points of enforcement, obviously, in the different jurisdictions. But if you could find a way to introduce that into your conversations, because the challenge is reconciling the intent of a statute and then implementing regulatory control to tighten that up is a never-ending moving line, as you well know. So we're going to be relying upon you to convey this information and hopefully to convey our sincerity and our deep, deep concern about what the vulnerability of our election. And we are 5 months away from our primary. So we're looking for that. And then the other thing I would say, I would like to know, and if I've missed it, that's on me, but what means of progressive discipline is going to be incorporated into your proposed regulations for poll workers and counties, so whatever the regulations are, if they are not complying with that. That's something worth considering. Obviously, regulations pertain to the governing authority that's holding the election. It doesn't apply to the voter who may be misrepresenting their identity, et cetera. So those are points I would advance, and thank you again for your time and the broad spectrum of conversation that you've enabled here. Thank you.
My pleasure, Ms. Martinez, and thank you for your comments and time. At this time, is there any other general public comment? Before I get to Mr. Williams, I can't find it right now. I will admit it's likely a deficiency of my own, perhaps.
We'll talk later. You encouraged me and others to meet with you later. And that's it. We can bring it all up later. I don't want to, this has been a really long day. You are so impressive. I'm amazed. You're holding up okay? Because I don't know. You're doing great, Jay.
I am. Thank you. My coffee went out. It expired kind of a while ago at this point, but I'm good. Thank you for the consideration.
I just have one more thing. I would like, my concern is the Department of Motor Vehicles, their access to change voter registrations. I would like anyone who has access to those, the ability to the voter registration roll to be identified by login and time and date so that we know how and when these changes are occurring. Thank you.
Yes, ma'am. I can comment on that real quickly. The DMV does not have the ability to change anything in your voter registration. They as part of the AVR process, they collect information from their customers. It gets sent to the county clerks. The county clerks are their only ones who make any modifications to the statewide voter registration list.
I think one of the concerns is that there is a default when anyone has any interactions with the DMV, there's a default as far as their voter registration status. And so, because there are reports of people having their registrations changed just because they visited DMV, but it was not for a voter registration issue.
I know about that. In fact, I can explain. And bottom line, it's been resolved. That was there was a process or a procedure in a discussion that we had about with the DMV. If somebody leaves their party affiliation blank, what do? Do you and of course, the right answer was not put anybody into a party. So then the system was set up so that it identified in that information that the registrant left it blank. And because it was blank, the question was, well, let's move into an other. When that happens, the county clerk, again, would notify the voter. You get a postcard notification saying you've been registered to vote through the AVR process. Your party affiliation is other. And in many cases, that enabled an individual to note about it and to then change it through the county clerk. This became an issue in 2 points, though, and that we've identified and resolved. In one case specifically, right? If you went onto the MyDMV portal and you left it blank, then it would transmit that you left it blank and you get shifted to other. What we have since added to that is if the individual making the transaction already has a party affiliation, leave it alone. Don't change it to other. Even if they indicate on their form, the indication on their form of it being left blank is not them saying they want to go to other or to not be affiliated with any party, which was kind of how the process was initially set up. That was resolved last month, and postcard notifications went to everybody that was affected across the state, specifically because we wanted them to be aware of this process before that we get to the primary, right? Because of our closed primary system. So that's again a little bit behind the scenes. And speaking of complex business processes, certainly available to talk more about the AVR process and what we're continuing to do to work on that separately. But I think maybe I've
Thank you. That was really helpful. Excellent news. But when you say other, do you mean nonpartisan?
So yes, ma'am. No party affiliation. Not, and in fact, there's a designation that was again, without getting to like the coding systems and how it was broken down, but yes, it was a nonpartisan affiliation. Yeah.
So my comment or request to have all access, yes, anyone with access to the voter registration.
And that's again, that would go to the clerk, and the clerk would actually, okay, this individual went to the DMV and left it blank. They want to be in others. It's kind of how it was implied. But now we have it set up so it says left blank. So, and we've corrected the business process so that when a clerk gets that document from the DMV, now it says Ms. White went to the DMV. She left her party affiliation blank. The clerk will look, oh, it says Ms. White is this party. Got it. She's already on one. We're not going to touch it. We'll leave it alone, and so that change will not be made. Incidentally, if you reach out to your clerk or registrar and say, I'd like to know, do you remember what day I changed to nonpartisan? Or there was a time when I went back and forth between 6 different party affiliations in my college years or whatever, they will, well, again, depending on how far back that was, the clerks will have all that data and can provide it to you so that every individual transaction modification to your voter registration that's ever occurred while you were registered in that county is captured and available for your review.
Okay, yeah, but just to clarify, I would like a footprint, documented footprint that's saved as to who was in the system to make that actual change, whether they're DMV. See, because if you go to the county clerk and ask that, they say, well, that's not my bailiwick. It needs to go over to DMV. And then go talk to DMV and they say, no, that's not go talk to Secretary of State or their voter registrar. So yeah.
Contact me, ma'am, please, and I'll get the answer for you.
Okay, thank you.
Yes, ma'am. At this time, is there any other comment not related to an item that was on the agenda earlier today? Excellent. Please note that the Secretary of State may propose additional amendments following consideration of today's testimony and any further written comment from the public that I just noticed continues to come in. So thank you to those individuals who are continuing to provide comment. To ensure you receive a copy of the amendments in advance of the adoption hearing, I encourage you to sign up for the e-notify system through the Secretaries of State website that I actually have already included in the chat. If you have any problems, please contact our Elections Division at 775-684-5705. Again, thank you all for your comments and participation today. I know it hasn't just been me that has enjoyed the discussion over the last 5 hours. So again, I truly appreciate your involvement in this process and your voices to help us make these regulations better. If there's anything else that comes up, please don't hesitate to ask or reach out to the Elections Division. Otherwise, I hope to see some of you tomorrow as well. Thank you and have a good day.